Morning, we're here for day 2 of the Utility Facility Review Board hearing in the matter of docket 20-35-3, Rocky Mountain Power versus Midway City. We have all board members present and counsel for all parties present. When we concluded yesterday, we had just completed cross-examination of Mr. Benjamin Clegg. There was some discussion of copies of the NESC codes that he referred to in his answers to certain cross-examination questions. There has been some written communication among all the parties since we concluded yesterday. So at this point, I'm going to ask if any party has any further comment or any issue with respect to this issue before we conclude with the testimony of Mr. Clegg.
Your Honor, this is Mr. Morris. I'm just checking emails to make sure there's nothing since we received word last night by email that Rocky Mountain was not willing to share a copy of the code that their witness read into the record yesterday, purportedly because of copyright concerns. I've read the copyright notice on the one page that they sent, Your Honor, and I want to move to strike Mr. Clegg's testimony that read into the record something that Rocky Mountain is not willing to share with the parties, that we had no advance notice of. And as I read that copyright notice, it expressly permits the code to be made part of a public proceeding, which this is. And this is a pretense by Rocky Mountain to prejudice Midway and Volt and get into the record something that they're not willing to allow us to fully explore and read. And this also deprives the board of the same opportunity. And the idea that we have to go online and buy something that they read into the record yesterday is preposterous. So I move that Mr. Clegg's testimony referencing that code be stricken from the record.
And this is Corbin Gordon,
Mr. Morris.
Oh, I'm sorry.
Yeah, before we move on to any other responses to the motion, so we have a motion to strike. I want to ask Mr. Morris a question or two, and then see if other board members do. The motion to strike would be, to me, a different scenario if the material had been read into the record as part of Mr. Clegg's direct testimony. It was in response to cross-examination questions, and I'm curious if you're aware of any precedent on point that would prevent a witness from referring to materials outside of the record that haven't been admitted into evidence in response to cross-examination.
Under the rules of evidence, Mr. Chairman, this is hearsay. We don't know whether he was reading accurately, whether he was paraphrasing. And as it came in, I think we all assumed that we'd be getting a copy of it and that copies could be made part of the record so that there was never any dispute about what the material he was reading from said. And for that reason, I didn't object at the time because it seemed so simple. The proposition that we would be provided with copies of what he had fortuitously laid his hands on and had at his disposal to read to us in response to cross-examination. And so because it is hearsay, because it is unreliable, because it is incomplete, because we are prejudiced, because we have had no opportunity to review and read for ourselves the material that he was reading from, and because the copyright notice on which they rely to keep it from us and from you as the board expressly permits the publication by a public body in a public proceeding.
One more follow-up question then, Mr. Morris. Would your objection be any different if Mr. Clegg had limited himself to summarizing his view of the NESC codes rather than reading provisions of it into the record?
it would be moderated a bit because then the board would be presented with, an opinion by somebody of something else that's written. But given the reliance Rocky Mountain is apparently placing on this document, and the fact that if it was going to be read in, I mean, this is not something they didn't anticipate, Mr. Chairman. He didn't just happen to have it with him. He was armed and ready, sitting with counsel during his examination, with no opportunity to see what or how his counsel was signaling him or opening the pages for him or anything like that. I still think we're just as prejudiced by having him say, oh, by the way, I think NESC says X, Y, and Z. If that's all he'd said, I probably wouldn't think it was important enough to worry about. But when he purported to read it chapter and verse to us, without everyone in the room having the ability to see what he was looking at and reading from, I think that compounds the problem.
This is Thad LeVar. If any other board members have questions for Mr. Morris at this point, please jump on and let me know. I'm not hearing any questions from board members at this point. Mr. Gordon, you were, I think, before I was asking the questions, we're trying to interject your position on the motion. Why don't you go ahead and do that now?
Yeah, we just wanted to join the motion on the record, so Midway City joins Volt's motion to exclude and to strike.
Okay, thank you. Mr. Reich, do you want to respond to the motion?
Yes, I do. We obviously would oppose that for several reasons. First of all, it's the one that you pointed out. This is a question that was asked by the parties for an explanation of what our specification was based on. They were given the answer that it was based on the National Electric Safety Code. They're the ones that asked the question. This is a code that's open to everybody if they pay for it. So they have as much access to it as we do. Mr. Morris is incorrect. We're not trying to hide the ball. There's nothing nefarious about not producing the document, but expressly states on the copyright provision that it's public authorities are granted permission to republish it. We're not a public authority. So it's our view that that would be a violation of the copyright provision. It is in response to a question that Midway City asked Mr. Clegg. I think that it's interesting if you put this in perspective. I mean, I don't think this proceeding is really about Rocky Mountain Power justifying every specification we have and what code title it's supported by. But that's what they asked, and we gave them the answer. So I think this whole line of questioning is outside the scope of the board. But to the extent they've asked for it, we've given it to them. And I think it's more accurate for Mr. Clegg to read it than to summarize it in his testimony, because then you don't know if his summary is correct. So it's our position that it was read accurately. The parties can certainly purchase a copy. I'm surprised they have experts. I'm assuming their experts have copies of the National Electric Safety Code, and they can refer to it. I provided this morning in response to Midway City's request the references that he read. So they have every means available that we do to confirm what was read in response to their question.
Thank you, Mr. Reich. Do any board members have questions for Mr. Reich at this point? Okay, let me bring those.
May I respond, Mr. Chairman? Mr. Morris.
First, let me see if any board members have questions for Mr. Reich. Do any board members have questions for him at this point?
Yeah, this is board member Jordan White. This may be a question for Mr. Reich and or Mr. Morris. The scope of the questioning. What are you hoping? I guess this is for Mr. Morris. What would you suggest the strike be? In other words, if the question was, what did you rely on at the NESC code? Do you want that also excluded, or is it just the specific reading in of the verbiage from the code?
It is just the reading in of the verbiage of the code without the board or us having an opportunity to follow along and to see it in context.
Okay.
Thank you. Any other questions from the board before we let Mr. Morris give any final thoughts on his motion to strike? Okay, Mr. Morris?
If everyone could look at the page that Mr. Reich emailed out to the board and to council last night in purported support of his withholding this information, he highlighted the language at the bottom, and I'm going to read this verbatim, quote, "Public authorities are granted permission to republish the material herein in laws, regulations, administrative orders, ordinances, or similar documents, period. No other party may reproduce in any form, in an electronic retrieval system or otherwise, any portion of this document without the prior written permission of the publisher." Now, I submit that Mr. Reich violated this copyright when he emailed us a copy of this page, because he's reproduced it, any portion of the document, which is a page from the document, and he didn't get written permission from the publisher. And so it's convenient to violate the express terms of this on the one hand, but purport to honor it in another. And I submit that the permission for public authorities to republish this material presupposes that the material would have been provided to a public authority. And this is a public proceeding. We're not making money off of this. We're not reproducing it and taking away money that otherwise would be going to the publisher of this material. But in a public proceeding like this, they've expressly authorized it. And if Mr. Reich is permitted to print one page of this and share it with the world, he ought to print the other pages that Mr. Clegg read from yesterday and share those with us. That's all I have. Thank you.
This is Thad LeVar, and I'm going to suggest what I think might be a way to deal with this objection, or at least to put it off till later in today, that I want to run by parties and board members. The Public Service Commission, which provides staffing support to the Facility Review Board, owns a license to the NESC codes because we reference them in our administrative rules. So to cross-reference them and incorporate them by reference into our administrative rules, we've had to purchase a license. We could probably have staff members from the PSC check by the lunch break and know after the lunch break if the PSC could provide to parties and into the record the referenced subsections. I don't think we would probably look to enter the entire NESC code, but if it's possible for us to pull out the subsections that were referenced by Mr. Wright in his email early this morning, that's a possibility. So I'm suggesting that as one way forward, or at least we can find out by the lunch break, and if that doesn't work out to the resolution of all parties, we can address it after lunch and potentially recall the witness or deal with the motion to strike. But first, let me see if there are thoughts from parties on that path forward, and then I'll go to board members. So first, Mr. Morris, and then I'll go to Mr. Gordon and Mr. Reich.
That sounds like an elegant solution, Mr. Chairman.
Mr. Gordon?
The only concern I would have is, and this goes more to the board so you understand why we would be concerned about this, Rocky Mountain Power has a duty to put on its evidence and prove its case. And one of the core issues that we're talking about here is what the actual excess costs are going to be, and part of that's going to be to justify why they put in their specifications that dual trenches are a requirement under this code. And so if you don't have that code, which has not been submitted to you in any of the direct, it's going to be very difficult for you to determine if that is an actual legitimate specification. And so this really is the crux of really the next witness that's coming up in Mr. Darren Myers, we're going to run into this problem again. And I'm hesitant to just say, yeah, we're going to do something as a workaround. And so, because Rocky Mountain Power, in my opinion, at this point is refusing to prove its case. It's really got the responsibility and obligation to come in and demonstrate, and it really hasn't. And so, on some levels, I'm just going, if they don't want to provide this to the board, you're going to be left with no information to make that decision. The record will be blank, and I'm not in opposition to that. And so I don't know that I'm necessarily in favor of trying to work around and allowing them and trying to prove their case for them. So that would be my only concern, is if they don't want to put the evidence on, I think it's only fair to say it's not in the record, and we'll proceed forward and we'll make argument on that at the end of the trial.
Okay, thank you, Mr. Gordon. We'll go to Mr. Reich. I'm just going to comment, though. I would find those concerns more well-founded if the NESC code had been referenced in Rocky Mountain Power's direct testimony. I'm having difficult time agreeing with those concerns, considering that it was in response to cross-examination questions. But let's go ahead and go to Mr. Reich and then back to the board.
Two comments. We're fine with your suggested route to have somebody look at that. The second question I have, which maybe goes to more of the whole issue, even in Midway City's estimate, they have 2 trenches identified, even in their reduced spec, the Volkswagen version of this line. So we're kind of having a difficult time understanding this whole line of questioning when even their own expert provided for 2 trenches. So this whole line of questioning is interesting, and like I said before, I don't think we're not meeting our burden by not explaining every specification we have in this testimony that's going to come up now. We'll go into more detail on that.
Thank you, Mr. Reich. Let me go to any board discussions or any questions or comments from board members.
Yes, I have a comment. This is Glenn Wright. In my previous life, I had regular access to NFPA 70. I find it incredibly unlikely that the city of Midway doesn't have access to NFPA 70 because they have people out inspecting buildings and enforcing the electrical code. I look at the legal maneuvering on both sides here as a waste of time for us this morning. Rocky Mountain Power could have provided this. The lawyers for Midway could have obtained this from Midway, and I think the chair's proposal is eminently a good idea.
Any other board comment?
Yeah, this is Board Member Jordan White. I support your proposed solution, and I would assume that the NESC code will probably be discussed in other witnesses' testimony at some point. This is the underpinning of the design, it sounds like. So I don't see how we can ignore it. So I think this is probably the first best solution to address this concern.
And this is Dave
Thank
Clark.
you, Mr. White. Mr. Clark?
Thank you. I support the solution that you presented to us, but I don't want to imply by doing that I wouldn't also support the continuing existence in the record of the references yesterday. That's not a resolved question for me, even if somehow the Public Service Commission is unsuccessful in obtaining the access that we hope for.
Thank you, Mr. Clark. And just to clarify, I think what I'm proposing is that we don't act on the motion to strike at this point, but when we return in the afternoon, when we find out if the Public Service Commission staff were able to provide this, we could deal with the motion to strike if necessary at that point.
Yeah, good. Okay, that's great. Thank you.
Any further board comment or questions? At this point, I'm presuming that the Public Service Commission legal counsel, Mike Hammer, is listening to this proceeding. If you are, I'm going to ask you to get in touch with Carol Revelt, and I've just forwarded to the two of you the specific NESC sections that Mr. Reich emailed to parties early this morning, and hopefully we can find out by noonish whether those can be extracted from the PSC's license and provided. And with that, I think we're ready to move to Rocky Mountain Power's next witness. Does anyone have anything further before we do so?
This is Corbin Gordon from Midway City. We'd just like to reserve the right to recross Benjamin Clegg depending on the outcome of what we've discussed as far as making this available.
Okay, this is Thad LeVar. I'm going to ask if anyone has any objection, and I think we have to understand that while we're doing this telephonically, recalling a witness may take a little time to get the witness back, and we might have to adjust for that. But is there any objection to that request to reserve the right to recall him? Okay, I'm not hearing any objection, so we'll move forward with that understanding. I'm going to just make a comment of my own observation. This is speaking for myself and not for the other board members, and they may disagree with me. But I'm going to comment that I feel like yesterday we had a high volume of repetitious cross-examination. We're not dealing with a jury here. We're dealing with 5 board members who have read all the filings and read all the testimony. So I would encourage parties to try to be less repetitious in their cross-examination today, and that's all I'm going to say on it. At this point, Mr. Reich or Ms. Gordon, you may call your next witness.
Rocky Mountain Power calls Mr. Darren Myers.
Okay, and we have an objection to Mr. Myers' testimony, so why don't we start with Midway City. If you want to give us, we've all read your objection, but if you want to give any brief verbal comment on it before we move forward, please do so.
Yes, this is Mr. Dukes. I'll make it very brief if you've read the objections. Mr. Myers is a project manager, works for Rocky Mountain Power. The bids were submitted by third parties. There were 18 contractors that the offer went out to, and only 3 responded. The problem we have is that the bids are all anonymous. We don't know who any of these contractors are. None of them obviously are witnesses here. The numbers in the bids themselves are quite generalized. Mr. Myers doesn't have any personal knowledge of them other than he just received them. So it's very difficult and impractical for us to be able to challenge them under these circumstances. And we think it's unfair to Midway City and Volt as well that these bidders aren't present to testify and lay a foundation for the actual bids. So I think much of the questioning of Mr. Myers will be, well, I'm not sure. You'd have to ask the bidders, which we can't do. We submit that his testimony should be stricken.
I just have one brief question. Are you aware of any precedent from any state where in a court or an administrative proceeding where a public utility was not allowed to put into evidence results of bids without putting the bidders on the stand to provide foundation?
Am I aware of a administrative tribunal where they were not allowed to put on the bids because the bidders weren't available?
Administrative or judicial, but I'm looking for something that's similar factually, dealing with a public utility receiving bids and being required to put the bidders on the stand to present into evidence the results of the bids.
I mean, I'm aware of the general rules of evidence as you are as well, as to hearsay and foundation. I'm aware that this board is allowed to receive hearsay evidence. I'm also aware that they can't rely solely on hearsay evidence. And given what Mr. Myers is going to rely upon for talking about these bids, it's all hearsay evidence. Now, he may have some independent knowledge not specific to these bids, and I don't have a problem with that. But when he's talking about the specific of these bids, they are hearsay, and he doesn't have the proper foundation or knowledge. Sorry, he doesn't have the proper knowledge to lay a foundation for them. So whether I don't have a specific case in the context of bids, but there are many cases out there where someone tries to introduce documents that were prepared by another person, and they don't have enough knowledge to lay a foundation that's deemed to be hearsay.
Sorry, just one more follow-up then. Is it your argument that it's hearsay for Mr. Myers to testify as to the facts of the bids that he received? I mean, to testify as to these are the bids received and this is what was in those bids?
It is hearsay to testify as to the content of the bids. They're offered they're out-of-court statements and offer for the truth of the matter asserted. That, for example, this bidder bid this amount and the total bid is this amount and this is what constitutes those bids, either the various constituent parts, and maybe even what we want to know is why. Why were the bids, why did the bids come in at this amount? Is this a realistic number? What were they based upon? That's one of the primary focuses of this board, to see if these bids are legitimate. And there's really no way for us to cross-examine Mr. Myers on that because he doesn't have personal knowledge. And the only way you can get that knowledge is by looking at an out-of-court statement, which is offered for the truth of the matter asserted in the statement.
Any other board questions for Mr. Jukes? I'm not hearing any. Mr. Morris, do you want to comment any further on this motion?
I'll take a cue not to. I'll take a cue not to be repetitive here, and the only thing I'd emphasize is we recognize too that the board is allowed to receive hearsay, but these matters that Rocky Mountain bears the burden to prove can't come in solely through hearsay. We and the board are all prejudiced because we have no ability to dig into someone claiming it's going to cost them $28 million to dig a couple of trenches for a mile. Mr. Myers may have solicited the bid and given them his conditions, but as to why they're charging that much, how they arrived at their calculations, all of us are going to be in the dark, and the board could never make a determination as to what an appropriate excess cost could be in these circumstances.
Thank you, Mr. Morris. Any board questions for Mr. Morris at this point? I'm not hearing any, so I'll go to Mr. Reich.
Thank you. This is Mr. Reich, Rocky Mountain Power. Your Honor, I didn't see any citations to any opinions in either of the written objections that were filed by Midway City or Volt. They have acknowledged that the presiding officer may not exclude evidence solely because it is hearsay. As you will see when we do the direct of Mr. Myers, that Mr. Myers was intricate part of preparing the bid specifications. He's talked to each of these contractors. I think a lot of their objections go to the weight of the evidence and not the admissibility. He's met with the contractors. He's familiar with the bids, certainly can testify about that. We've provided the written bids as we've received them to these parties. So we have a lot of evidence of what those bids are and what's contained in the bids. So with that, we would say that the objection should be denied.
I have just one follow-up question for you, Mr. Reich. Do you agree that the bids themselves, as discussed by Mr. Myers, do qualify as hearsay? I mean, we all understand the board's authority with respect to hearsay, but do you agree that that the bids themselves, as Mr. Myers discusses what was received and what was contained in them, is hearsay?
No, I would say they would fall within the business records exception to hearsay. They were received in the ordinary course of our business. We received bids, in the course of our business at Rocky Mountain on a frequent basis. And so I think they fall within that exception to the hearsay rule.
Okay, any other questions from board members for Mr. Reich? I'm not hearing any questions, so I'll go back to Mr. Jukes if you have any brief final comments on your objection.
Yeah, just in response to the business record exception, that requires the business records to be your own business records. So, for example, Mr. Myers could testify about ordinary records prepared by Rocky Mountain Power as an agent that he didn't personally prepare. But here we're talking about business records prepared by third parties altogether who are not a party to this case and aren't here to lay a foundation. So that exception doesn't apply.
Any other questions by board members for Mr. Jukes? Okay, any discussion by board members of the objection to Mr. Myers' testimony? Okay, I'm not hearing any board discussion. I mean, I can tell you my personal view. Maybe I'm not as well versed in evidence. I'm not convinced it is hearsay. I'm not convinced it's presented for the truth of the matter in the way that concept is generally developed in evidence. But putting that aside, the board certainly has the right to consider hearsay while a finding can't be based solely on it. So my inclination is to deny the objection. If any other board members want to weigh in any differently, I don't know if a board vote, we can take a board vote, but if I don't hear any objection from board members, we'll just move forward that way. Okay, I'm not hearing any other discussion, so the objection is denied. Mr. Reich, if you want to put forward this witness, do we have the witness on the phone right now?
We do. He is here.
Okay, Mr. Myers, do you swear to tell the truth?
Yes.
Okay, thank you. Mr. Reich?
Mr. Myers, have you reviewed the direct and the rebuttal testimony prepared in your name that's been filed in this proceeding?
Yes, I have.
And do you have any changes to make to that testimony?
No, I don't.
Okay, in addition to the testimony, I know that we have submitted and produced documents. I'd like to go over some of those documents with you at this time. First document is identified as RMP 1 through RMP 54, which I believe is what we refer to as the RFP or the bid document. Are you familiar with this bid document?
Yes, I am.
And can you explain to the board a little bit about the process that was used to put this bid document together?
Yes, after we received the conditions for the use permit from the city of Midway, we went to work on creating a bid document for building the underground transmission line through the city's boundaries. We took those conditions. First of all, we used a standard underground transmission template that we use for all projects similar to this. And we took the conditions, the multiple options that the city wanted to be bid out, and we put those into the document. And we used our standards that we use for every other project, and produced that document and sent it out in our normal process as we do for any other project that we're bidding out for construction.
Did you change any of the specifications in this RFP from Rocky Mountain Power's general specifications?
No, we use our standard specifications that we use for every underground transmission project that we build. All that was added or changed was the scope of work with the options that were requested by Midway City.
Okay, I've moved to submit the direct testimony, the rebuttal testimony, and this document, RMP 1 through 58 for Mr. Myers. Sorry, 1 through 54.
Sorry, would you repeat that? I was talking over you.
Yeah, I just needed to correct the base numbers on that.
Okay, thank you. Understanding that we still have a continuing objection from both Midway and Volt to this testimony, is there anything else that any party wants to say about this motion? Okay, I'm not hearing any. The motion is granted. Thank you.
Then, Mr. Myers, will you explain to the board briefly what you did with this RFP, how it was sent out, who, how many contractors it was sent to?
Yes, we just followed our standard process. After the bid document was put together, all the maps and attachments, pricing schedules, and all the reference materials were put together. We submit that to our procurement group, who then puts it out for a proposal on a system that goes out to all of our qualified contractors that are able to bid on a project. We sent that out. Generally, we give them a week or so to take a look at it, go out and visit the location, the site, and prepare any questions they might have on the project. We then held a pre-bid meeting, as we do with most all of our projects, on site, and sat down with the contractors and allow them to ask questions. They all said that they had looked at the site. They drove the line route, collected any information, data they had, and we had a pre-bid meeting. There were a few questions asked to qualify a couple of things, and we concluded the pre-bid meeting, and then we gave them the remainder of the time to put their bids together. During the process, we had no questions or any clarifications questions submitted to us through our procurement system. There's a very formal process where any bidder that has a clarifying question will send that in, and our procurement group screens that question, and they make it available to all the bidders. They send any of those questions in on to me, and I will, clarify those questions. They send that back out, and every bidder can see the answers. So it's a very formal process that we follow for every bid that we do. Anyway, so that time went by. We didn't have any clarification questions come up. We did have 2 requests to extend the bidding time frame by 2 weeks. We granted that so that they could provide the best bids possible. We then, at the conclusion of the bidding time frame, the extended time frame, their bids were sent into our procurement group. They were assembled and then sent to me, and I received all of those and was able to review them internally. We then I passed those on to you, Mr. Reich, who then sent them on to Midway City.
At any time, did you meet with any of the contractors out on the site?
We did have a pre-bid meeting at the Heber Light and Power building there, close to the site. All the contractors that attended that meeting, there were 4 who attended, and they said that they had driven the line route. They were familiar with it. We talked specifically about a few of the areas that they felt might be concerns for trenching. Heber Light and Power employees were there to help out. They're familiar with that area more so than we are, and we're able to provide some information that I think helped the bidders clarify their construction process. So yes, we did meet with them. We did talk with them. We answered questions. They were there on site. They looked at the location in detail.
And what are the names of the 3 companies that submitted bids?
Wasatch Electric, Res Group, and Summit Line Construction were the 3 that submitted bids. We had a 4th who attended that did not submit a bid.
There have been several allegations in this proceeding that Rocky Mountain Power somehow changed the bids or increased the bids or did something to intentionally change those bids. Based on your information, your knowledge, has Rocky Mountain Power done anything to increase these bids or change the bids that were submitted by these contractors?
No, not at all. In the summary of costs that was sent to Midway City, I added a line item for the dip pole structures, which was something that was requested in the conditional use permit. And I did add I won't use overhead in this scenario, but a surcharge that is an internal company, Rocky Mountain Power, surcharge that's added to all projects. But that was not in the bids themselves. They were separate line items to show our total cost for the project.
And I'd like to move to submit the bids into evidence, and I'm just going to refer to I'm going to go back to RMP 1, which starts with the bid specification, up through RMP 121, and then RMP 143 through RMP 148. I'd like to submit those into the record. I move to submit those into.
Okay, thank you. We've received the motion. I think this is, obviously, the objection to Mr. Myers' testimony is still outstanding. I think admitting the bids into evidence puts a little bit different twist on the objection. So why don't I ask if there's any objection to this motion?
Midway City just simply renews its objection based on foundation and hearsay.
Okay, thank you. Anything else from Volt?
This is Mr. Morris. We join in maintaining the same objection. Putting the bids in is no more helpful. We still can't talk to the people to put them together.
Okay, let me go to the board members if there's any discussion of whether we should address this motion any differently than we did the testimony of Mr. Myers. Discussion, or if you have questions for council. Okay, I'm not hearing any discussion. And considering that at the very least, the board has the authority to consider hearsay, the extent to which we can rely on it is certainly an issue. But I don't see a legal basis to deny the motion to admit these into the record. So the motion is granted. Thank you. Mr. Reich, you can go forward.
One last question, Mr. Myers, in your position as the project manager. Is your understanding that these bids as submitted to Rocky Mountain Power are binding bids? That if Rocky Mountain Power were to select one of the bids, that bid would be binding on the contractor?
Yes, they are.
Okay, I have no further questions.
Okay, thank you, Mr. Reich. Mr. Gordon, do you have any questions for Mr. Myers on cross-examination?
Certainly, thank you. Good morning, Mr. Myers. First question, just want to establish, you're the project manager of this project, correct?
Yes.
And you were intimately involved with creating specs for the bids, correct?
No. I don't create the specifications. I use specifications that come from our standards group.
So you were not involved in the creation of the length of the line in the bids, correct?
Yes. The scope of work, I guess, just to be clear, yes, we put the scope of work specific to a project, but any standard construction practice or materials used, that type of information is standard. That comes from our standards group. But yeah, anything specific to the project, yes, that was put in the bid by myself and our transmission engineer who worked on the project.
Okay, so I just want to make sure that I know what questions I need to be asking you. So you were involved and responsible for the length of the lines put in the specs of the bid, correct?
Yes.
Okay. And
along with our engineering group, yes.
Okay, but I just need to know who has final say. If there's a mistake in the length of the line, as the project manager, does that fall to you?
Yes.
Okay. On the dual trenches and that requirement, what I'm hearing is you did not create that specification and were not part of that aspect of the specifications. Is that correct?
I guess, can you clarify when you say dual trenches, what you mean by that?
Oh, I'm sorry. The specifications call for a dual trench to bury this so that Heber Light and Power would have one trench and Rocky Mountain Power would have one trench. That's what the specifications require. Were you involved in creating that specification?
I guess I don't know of a specification for dual trenches. We specified in the RFP that there would be 2 duct banks placed, one for Rocky Mountain Power and one for Heber Light and Power. Those could be in the same open trench, but there's 2 different duct banks to keep those circuits separate.
Okay, and were you involved in creating the specs then, so we have the same language for those dual duct banks?
I guess when you say specification, can you be clear on that? As a scope of work, yes, we needed 2 duct banks because Heber Light and Power and Rocky Mountain Power were having 2 specific distinct circuits that need to be independent of each other. Thus, we needed 2 duct banks. If we were just building a single circuit, there would just be a single duct bank.
Okay, and the question is there anything in the specifications that require those dual circuits to not be in the same duct bank, and where did you get that specification from?
Yes, we're 2 different companies, 2 different providers, and so we put together we will have 2 separate duct banks so that those can operate independent of one another. They could not be in the same duct bank if we needed to do any maintenance or take an outage or something on our circuit. We can't take down Heber Light and Power circuit at the same time and vice versa. So they need to be separate and distinct and apart, a distance apart to allow safe, maintainability and operation of those circuits.
And is that based? I'm sorry. Is that based on the National Electric Safety Code?
I'm not familiar with all of the National Electric Safety Code. It's a gigantic book. I don't know it in detail. Like I say, I take what our standards group gives us, and that's what we build.
So on the specific of the requirement to have dual duct banks, you really didn't create that specification. You weren't responsible for that, correct?
No. I guess if that's your detailed definition of a specification, it's part of the scope of work to put 2 duct banks in, yes.
Okay, so who was responsible for that? Who was the person that's responsible for that specification?
Our standards group.
Okay.
Is that not clear when I say who that is? They're employees of Rocky Mountain Power.
Yeah, and as far as just for purposes of today, is anyone from the standards group going to be testifying in this hearing that you're aware of?
Not that I know of.
Okay. So let's move now to the specification. There's a requirement to have an extra conduit installed in both duct banks. Are you familiar with that?
Yes, an extra conduit and conductor.
Okay. And so as far as let's just take them one at a time. The extra conduit, was that did that come from you, or you're responsible for that spec?
No, that's in our standard specifications from our standards. So that would
come from your standards group as well, correct?
Yes.
Okay. And the requirement to pull a spare line through that conduit, was that your spec or was that your standards group?
That's our standard. All underground transmission circuits that we build have a spare conductor installed.
But that specification comes from your standards group. You're not basing that on your own knowledge or the National Electric Safety Code. That comes to you from the standards group, correct?
Yes, we used a standard template that we've used for all the other underground transmission lines that we've built.
Okay, very good. Okay, so then is it fair to say that the specification that you were really responsible for then is the length of the line? Everything else that I've talked to you about came from the standards group, correct?
There's other variables in the construction that we, the length of the line, Probably, I mean, yeah, for the most part, it's standard specifications on how they build it.
Okay.
All the options were put in there, all the, the general scope of work that are specific to that project. Yes, I was responsible for those, but not the standard specifications of the company's underground transmission system.
Very good, thank you. In your testimony, you indicated that the project was designed to meet the National Electric Safety Code. Are you aware of any of the requirements or specifications in the bids that exceed the National Electric Safety Code?
No, not that I know.
Okay, and would that be a better question for the standards group?
I'm not sure.
Okay.
I couldn't tell you.
Okay, fair enough. As far as, so you had 18, you sent this out to 18 bidders, you got 3 respond. Is that low? Why so low of a response?
No, not really. On average, most projects that we deal with in the project management office, 2 to 6 bidders or so is generally, sometimes a few more, sometimes less. I've never seen more than, on average or general, never more than 7, 8 total bids.
Okay. In your creating the specifications, did you work closely with Heber Light and Power in this process?
Yes, we did.
Okay. And regarding the dual duct banks, did they request the dual duct banks, or was that just something that came from Rocky Mountain Power?
It was both companies together jointly. We needed to talk about how to operate these circuits once they're constructed, how to maintain them. The safety was a big factor of how our linemen are able to maintain and operate our own circuit independently and not interfere with the other circuit and be able to maintain a safe distance. So yeah, it was definitely a joint discussion.
Okay. And regarding the spare line to be pulled through the conduit, did Heber Light and Power request that their portion of the bid include that spare line as well?
Yes.
Okay. Just a couple of things on that. I'm not going to get into the specifications with you. Those are questions for other people. But just a couple of things as a project manager. The cost of that extra line appears to raise the cost of the project to Barry by approximately 20 to 25%, correct?
Yeah, it does raise the cost. I'm not sure the exact percentage you're quoting there, but yeah, it does add to the cost of the project, absolutely.
And I think the way I'm calculating that is you would normally run 3 lines, you're now running an extra line, so it would increase it by approximately 1/4 on the project. Is that a fair way to analyze that?
No, you're already out there, you're trenching, you're installing all this stuff, you're just pulling a 4th, you're putting a 4th conduit, pulling a conductor in. Yes, it adds to it, but not to that degree.
Okay, so, but it's fair to say it would increase probably the line, the cable costs by 1/4, correct?
Yes, the cable material itself, yes.
Okay. Are you aware of any situation where an extra line is not installed, that just the extra conduit is installed without the extra line?
Not in an underground transmission situation. We do builds into customer locations, other, options where a customer asks for that, but that's our standard that we stick to for all underground transmission.
Okay. And that standard, once again, comes from the standards group, correct?
Yes.
Okay. So just briefly on the surcharging, you included in your bid surcharges ranging from $373,679 to $858,427, correct?
Uh-huh.
And this surcharge would apply to all those who do general work on capital projects in the company who are not directly charging to that project, but are working on the project in a support role as needed, correct? That was your testimony.
Yes.
Okay. And Rocky Mountain Power does not internally install underground lines, correct?
Not transmission underground lines.
Okay. And in the bids, you stated that this project should be bid as a turnkey project providing all required material, label, and testing, correct? That was in the bid.
Correct.
Okay. And also in your testimony, it says that surcharges, if company resources are being used for construction, the full rate of the surcharge applies. If contractor resources are used, then a lesser rate is calculated and applied, correct?
Correct.
Okay. So in this situation, it seems like the only thing Rocky Mountain Power would be doing in regards to the underground section of the line is putting together the bid specs, which you did, perhaps reviewing the plans, and overseeing the contractor who installed the line, correct?
To a degree, we have any number of other employees that help out on projects that don't specifically charge time to that project. And so their additional resource help is what our finance group uses to come up with a surcharge rate.
Okay. And from what I understand, that surcharge rate is just a general rate that you apply to all projects without really analyzing them specifically for how much your people are going to be used, correct?
Yes, definitely. It's a corporate governance policy that's used for all projects.
Okay. And would you agree that in this situation where you're asking for a turnkey bid, that all required material, label, and testing is going to be provided by a third party, that maybe that would not be the appropriate way to establish the assessed amounts here?
No.
Okay. Was there any specific analysis done on this project beyond just what your standard corporate policy and numbers are?
Yes, I actually sent this to our finance group to review it. They came up with the surcharge rate that would be applied. Any project that's over $10 million total is applied a different rate. So they're the ones that come up with that rate.
But I believe, based on your testimony, isn't that just a standard rate that they kind of apply to all? If it's less than 10 million, it's 3.82, and if it's over 10 million, then it's a certain amount that's applied. Isn't that correct?
If it's under 10 million, it varies. But yeah, it's around 7 to 9%. If it's over 10 million, finance comes up with their rate.
Okay. So based on the lowest amount that you've put in on the surcharges, can you explain to me how Rocky Mountain Power could justify a cost of $373,679 as a surcharge to what looks like review a few plans and oversee a subcontractor in this instance?
I'm not a finance expert, so I'm not sure all their calculations they use for that, but I see this for projects all the time. Actually, this is on the low end.
And so, but you're not in a position to testify as to how those numbers were arrived at or how they're justified, correct?
Not fully. My general explanation is my knowledge of it.
Okay. And so those numbers really came from the finance department, correct?
Yep, but they're very much in line with every project that we do.
That's right. But the finance department would be the better ones to testify as to the creation of those numbers, correct?
Yes.
Okay. Okay, let's see here. let's move now to the overhead costs. In your testimony, you indicated that the typical overhead cost to build was $190 to $250 per foot. What is the basis of that? Is that just kind of based on your experience, or was that based on bids?
Just based on experience, past projects.
Okay.
Yes.
And I'm correct in stating that Rocky Mountain Power has not submitted any bids establishing the overhead cost of the Midway portion of the line, correct?
No.
Okay.
They weren't asked for. Part of the.
Okay, so there's nothing in the record that establishes what the overhead costs are, correct?
In my testimony, or?
Well, there's no bids in the record that establish what the overhead costs are, correct?
There's no bids, no, just what I stated in my testimony.
Yeah, so, and your testimony is based on your experience, as well as, I believe you said there was actual costs of another overhead project that you were involved with, correct?
Yes, I pulled actual costs from a very similar project that was just completed in March of 2019. And that was the.
But that wasn't this project. It wasn't specific to Midway's project, correct?
Mr. Corbin, could you just let Mr. Myers finish his question? I think you keep interrupting him. I'm not sure if you can hear him very well, but could you just let him finish his answer first before you ask him another
Certainly,
question?
I will do so. Absolutely, yeah, not a problem.
Yeah, so those were actual costs from an actual project that was completed, very similar to this one. And it was overhead construction.
Okay, but there's not a specific bid. I mean, that's just a general estimate of what this one might cost, correct?
I wouldn't say estimate. The word estimate to me seems very high level with a lot of, variance probably to it. This is our actual cost of a project very similar, so not a bid for this specific project, but I would feel comfortable with those costs, definitely better than an estimate, in my opinion.
Okay. Let me see here. Okay, there's some questions regarding the accuracy of the length of the lines, and you've testified that you were responsible for that specific specification that was included in the bids, correct?
Yes.
Okay. And in the measurements, there were 3 options given, and to aid the board just quickly, the 3 options in the bids were just within Midway City's boundaries. A second option was to extend the line further east and move the big dip poles off of the main road. And then a third option was to include moving the dip poles to the east and then also extending the line, burying it all the way to the substation on the west. Is that an accurate representation of what these bids represent?
Yes.
Okay. And in each option, you stated option number 1, the distance was 6,990 feet, correct?
Yes.
Okay. And in option 2, 7,400, and in option 3, 8,950, correct?
Yes.
Now, when we look at Google Earth, our measurements come out on option 1 as 5326, 5826, and 7395, which is a difference in each one of those scenarios at right around 1,600 feet. Are you aware of why the discrepancies are, there's almost a 1,600 foot discrepancy in every one of these options?
I don't know how I would know anything about your numbers or how you came up with those. We measured our distance and put that in the specification.
Okay, so your testimony is that those measurements are on the ground and that is the amount of trenching and buried line that the individuals were supposed to bid, correct?
Well, we followed the exact overhead route proposed and used that to calculate our distances. You need to also factor in each dip hole is around 100 feet high, and there are 4 conductors on each dip pole. There are 4 dip poles, 2 on each end, 1 for each circuit, Heber Light and Power and Rocky Mountain Power. That's an extra 1,600 feet right there that will not show on Google Earth. Also, these are in the bid, and in our pricing sheet, we actually have a disclaimer there that tells the contractors that they must verify distances of any cable, any ductwork, any conduit, anything that has distances in a bid. There is a disclaimer on our pricing sheet that is the sole responsibility of the contractor to verify and to bid what their actual costs of trenching, boring, installing cable at that distance. So this is a standard that we use for every project. We put in distances. We claim that they're not going to be 100% accurate, maybe, but the contractors will definitely go out there and verify that for sure.
Okay.
I would have received. Can I finish? I would have
Sure.
received questions. Definitely have in the past. That's always a discrepancy question we receive during a bidding process if a contractor has a question about a distance because that affects their pricing. I didn't receive a single question about any distances. They put together their bids and they do their own measuring to clarify that.
Okay, so let's talk about that 1,600 feet on the termination structures. So that is cable that will go, that will not be buried, correct?
Yes, it comes out of the ground, goes up the dip pole, and connects to the overhead line. It's part of the underground system, even though there's a section that comes out of the ground.
Right. So, but based on the measurements that you gave them, it looks like you've included that 1,600 feet as being buried, correct?
No, that's just the cable. Yes, definitely the distance of the cable. It stops at the dip pole and there's a riser.
Can you show me anywhere where there was a disclaimer saying that they should take 1,600 feet of the length you gave them and remove that from the bid to bury? Is there a disclaimer that anywhere that explained that to them?
No, we say the contractor is solely responsible for determining the price, quantities, and lengths of the construction piece. These contractors know what they're building. They went out there on site and they bid a competitive bid as to the entire distance from end to end and the cable connecting up the dip poles to connect into the overhead system.
Okay.
So again, like I said, they don't just go off of our numbers. They verify and they prepare their bid off of their specific details of the project from end to end.
Right, and that would be some of the issues that we've talked about, right? You're not specifically aware of what each one of these did or how they interpreted that, correct?
No, they put together their bids and put the best possible bid. Thus, the difference, I think, between an estimate and a bid. An estimate is a high level, I'm going to take this much feet and times it by a factor, where a bid is specific. They go out and look at every single detail, add that up and put it in, and it's a binding bid. I think that's...
And so if they bid based on your specifications, then they would have bid to bury an additional 1,600 feet of the cable, correct?
No, I don't believe that.
But you can't say for sure, correct?
I'm fairly sure of that. They bid these projects all the time, every day.
But you cannot testify that you know absolutely that these individuals didn't just take your specifications and bid them based on what you gave them, correct?
I don't know, absolutely. I didn't interrogate that part.
Okay. And so let's just look at what the potential impact of that could be. So if they let's just take bidder number 13 and the bid on the 6,990 feet, the shortest, the option 1. The total bid on that was $12,582.43, correct?
Can you repeat that again?
Sure. The bidder 1 bidder 13 on option 1 to bury 6,990 feet of cable bid $12,582.43, correct?
Let me find that on here to verify. You said bidder 13?
Yes.
And you're on the table?
It's on RMP 101. I apologize, so that you can find it faster. And I think this is actually given in your testimony as well. There was a summary of it.
Okay, RMP 101. And this is...
Or if it's easier, in your testimony, it's on page 4 at line 15. You gave a summary of the bids.
Okay.
So based on that bid, if 1,600 feet was included to be buried that wasn't actually buried, that's approximately 24% of the total length of the line in that area, correct?
Oh, I see what you're saying, but the 1,600 feet was not spec'd to be buried.
Well, that's can you point to anywhere in your bid that says, or specifications that say they're not supposed to bid the lengths that you were in charge of?
In our summary of work, let's see here. In our summary of work section, it says, number 2 here, cable pulling, 5,390 centerline feet per circuit. One circuit total equals 4 cables, including a spare cable. For option 1, 5,800 centerline feet per circuit. For option 2, 7,350 centerline feet. For option 3, 7,735 centerline feet for Heber Light Power, and 8095 centerline feet for Rocky Mountain Power option 4.
So it's your testimony then that those are the specs that would remove the 1,600 acre feet, or sorry, not water, 1,600 feet of cable on the dip poles?
Yes, that's for the trenching distance there, the 59 or 5,390, and then the 1,600 more is not trenched. It's going up the dip poles.
Okay, and can you tell us where you're pulling that from so we have that reference so we can review that?
Yeah, it's in the it's in the RFP. Let me pull it here. Why is this mouse not working? It's in the summary of work section 5, number 2. Summary of work A, number 2.
Okay. I'm just making note of that. Okay, let me see. I'm just glancing down here. Give me just a few moments.
This is Mr. Morris. Mr. Myers, is there a Bates number? Is there a number on the bottom of the page you were just looking at? That might help us get to it more quickly.
Bates number, let me see. Hold on, I'm going to the, where is this? Let me see. Let me find it here. I've got a separate copy. Okay, sorry for that.
Oh, that's okay. Did you find, I'm sorry, were we still waiting on a response to Mr. Morris's question? Did you, I'm sorry.
Yeah, the version he was looking at wasn't Bates numbered, so we just gave him a Bates numbered version that he's trying to look at to find the reference that he just referred to. In fact,
Oh, okay.
Might be helpful if can we take a 15 or 10-minute break and we can get him to the right place on that?
If I'm almost done with my questioning, I mean, I have no problem. Oh, I think it's page 12. We're just looking for it right now. If we want to just finish up with my questioning or however the chair would like to proceed, I'm more than happy.
You know, it's a pretty good time for a break right now anyway, so why don't we take a 10 or 12-minute break, come back at 10:30, and then you finish your cross-examination, Mr. Gordon, at that point?
Sounds great. Thank you.
So we'll be in recess until 10:30. Thank you. I've been told there's about a 10-second delay, so the streaming could have been started and I'm just not aware of it.
Sorry, we're back. Midway City is back.
Okay, thank you. I'm just waiting for the online stream to restart before we go back on the record.
While you're waiting, this is
Okay,
Jay
it's
Clark.
on.
I'm on the phone.
Okay, thank you. The stream is back active, so we will be back on the record. We can restart the transcript, and Mr. Gordon, you can continue with your cross-examination.
Okay, so just a couple of questions here. So can you, I'm sorry here, I've lost track of the name. Mr. Myers, can you pull up the bidding pricing sheet for contractor 15 on option 1?
Do you have a
And that
base
would be
number on that?
Yeah, RMP 000111.
Before we do that, this is Heidi Gordon. Did you want Darren to clarify the base number?
Oh, yeah, we did need to do that. So if he can put on the record what the base number was on that. Yes, if he could put that on the record, that would be helpful. Thank you.
RMP 000012.
Very good. Okay, thank you. Okay, so now if you can pull up the bid from bidder 15 on option 1, and that is RMP 000111.
Okay.
Okay, and on your specs, you indicated that there would be 6,990 feet of trenching, correct?
Correct.
Okay.
Well, they've got trenching in here at 6990 feet. Our specs did not say that the trenching was 6990 feet. It said the end-to-end cable was estimated at 6990 feet. But again, for the contractor to confirm that.
So they bid it based on your spec of 6990, correct?
They put 6990 in here, yes.
And 1,600 feet of that is cable that's not going to be buried, correct?
In our RFP, it's called out that 1,600 feet would not be buried. We did not give a trenching distance, though.
Okay. Can you now turn to the bidder? Which one is this one? Bidder contractor 17. Same one, option 1.
Yes.
And isn't it true that they bid the full length of the 6990 trenching as well?
I mean, where are you at, RMP 119?
Let me give you it's 119, yes.
Right, and you're under...
It would be under trenching, and they basically just doubled the 6990, correct?
Yeah, that looks like the number they have in there.
Okay, isn't it correct if you go back to bidder, let me see which one the first one was. Give me just a moment here. We're trying to find it. Contractor 13, and that's 00099. And this was the low-cost bidder, correct? Oh, maybe it wasn't. I'm sorry. Maybe strike that last question. I don't think that's accurate. But based on this one, it looks like this is the only bid that actually accurately put the trenching at the 5329, correct?
They have 5329 in there, yes.
Yeah.
Accurately, I don't know, if the trenching is whatever distances they estimated or came up with when they went out on
Okay.
site.
So the question I had before, it appears then that 2 of the 3 bids have bid to trench an additional 1,600 feet of line that they should not have bid, correct?
I wouldn't say that.
You wouldn't say that, but their bid includes trenching at those lengths, correct? And that makes up the bid price, correct?
They put that distance in the trenching.
And do you have any reason to believe that they did not rely on that number to come up with the total amount of what it was going to cost to trench?
Well, just like I referred to earlier, that's a disclaimer for the contractors to go out and verify the distance.
But it would appear then that they did not verify in this situation accurately, correct?
I couldn't say.
Okay, but I believe your testimony prior to was that you were absolutely positive that they went out and did that, but it doesn't look like that's accurate, correct? You're not sure what they did, correct?
Yeah, they went out and said that they drove the line route and, looked at the construction specs and were preparing their bids off of that.
Okay, and based on these numbers, let's just assume that they misunderstood the specification. That means that they've overbid in option 1 approximately 24%, correct?
If they misunderstood that, yes, but like I said, there's always questions if there's a misunderstanding that they will bring up.
But they didn't bring those up to you, correct? That was your testimony prior.
No, we didn't have any questions.
Okay, and 24% of the total bid price of $12,582,043 is $3,019,690, correct?
Yes, I guess I'll do the math, but I don't know.
Okay. I think with that, I don't have any additional questions.
Okay, thank you, Mr. Gordon. This is Thad LeVar. Mr. Morris, do you have any cross-examination questions for this witness?
I do. Thank you, Mr. Chairman. Good morning, Mr. Myers. My name is Mark Morris. I represent Volt. Are you familiar with what that entity is?
Yeah, at a high level, I think.
Okay. It's a collection of landowners that own property along the line through Midway. 15 of, well, you said you put the bids out to 18 qualified contractors. What did you mean by qualified?
We have a list of pre-qualified contractors that we put bids out to for all of our construction projects. They've been through our procurement process, which qualifies them as, there's a number of criteria, technically qualified to be able to build to our standards. There's insurance involved, bonded, financial backing, those types of things is what the qualified piece would mean.
And the names of the 3 of the 18 that actually put bids in were what again?
Wasatch Electric, Res Group, and Summit Line Construction.
And so it sounds like those are contractors who don't necessarily themselves have trenching expertise, that they would sub it out, or do you know for those 3?
I don't know. We have, like I say, a number of contractors that have their own gear. Some don't. Some subcontract. Some work with each other. there could be a number of scenarios where sometimes they'll have trenching equipment on a project during a certain time, and other times they won't because it's being used other places. So yeah, there could be any number of variables
Okay.
during the construction process.
You didn't listen to any of the testimony yesterday, did you?
No.
Can you tell us who's in the room with you as you've been testifying this morning?
Yes, Heidi Gordon, Brett Reich, Nicole Kendall, yep, and Ben Clegg was in here this morning when I came in.
Okay, and there's a Mr. Kendall there?
Nicole Kendall?
Oh, Nicole, I'm sorry. All right. During your testimony, has anyone in the room been showing you things or putting papers in front of you?
No, there's a number of papers here in front of me, yes, but not from anyone else.
Okay, thank you. You said there was a similar project done in March of 19. Where was that?
That was Purgatory Flats is what it was called. It's in the Hurricane St. George area.
And how many, what was the linear feet on that?
I'll have to see if I have that with me. It came out to about, that was an overhead double circuit line. I'll have to find the feed. I don't have the exact footage with me on it.
Okay.
Let me see here.
What's the last underground transmission line you were involved with that had a length of at least a mile?
From a project manager standpoint, none. I've been involved in our capital investment group. Was a previous role here. I was involved in 2015 from a capital investment standpoint.
So you've never been a project manager on an underground line?
Not a transmission line.
Okay. Were you with Rocky Mountain Power back in, let's see. Are you familiar with the underground transmission line that Rocky Mountain built along 39th South that ran from 9th East down to Main Street?
Yeah, not intimately, but yeah, there's a line there that I know of.
Do you know who the contractor was that did the trenching on that?
No, I don't.
And the transmission underground line in Draper went from Dimpledale down to 10th East and then turned south. Are you familiar with that line?
Yes.
Do you know who the trenching company on that was?
No.
All right. You indicated earlier that a single trench could accommodate 2 duct banks. Just for the benefit of the reporter, could you spell how duct?
D-U-C-T, duct.
Okay, duct banks. How wide would the trench have to be to accommodate the 2? Do you know?
On this specific project, about 8 feet.
And if there are 2 trenches, how wide would the 2 trenches have to be? Or would each of the trenches have to be, and how far apart would they have to be, based on what you want?
our standard calls out for 23 inches wide for a duct bank, per duct bank. And we had 4 feet between the two on this project so that we could operate and maintain each circuit independently and safely.
So it sounds like you want 4 feet between the duct banks.
Yes.
Okay. I'd like you to look at page 9. Do you have your direct testimony in front of you?
Yes.
Go to page 8, if you would.
Guess I don't have an 8. Mine stops at 7 in this book that's printed out.
No, I'm sorry. I've got the page wrong. Anyway, I think you stated that Mr. Gordon asked you about the extra cable, and we had some testimony yesterday about a deadline going through. You remember? Are you familiar with that?
I wasn't in yesterday, so I'm not.
No, I know. Are you not? I'm sorry, bad question. Are you familiar with the spec called out to put in a line that is just going to be dead and won't be energized?
A dead line.
Are you referring to the spare conductor?
The conduit that's going to have a line pulled through that won't be energized, and it'll just be there for emergencies, I guess.
Oh, yeah, a spare conductor, yes.
Okay, I don't know the terms of art. Deadline is how I've been thinking of it. Is there such a deadline every time you install a transmission underground?
Yes, there is. In our current standards and specifications, any underground transmission circuit we build will have a spare conductor installed in it.
If that's the current specification, was there a time when your specifications did not call that out?
Yes.
When did that change?
To my knowledge, it was 2015, I believe, when that was updated.
Okay. And maybe I'm the only one on the line here that doesn't understand this, but these capital surcharges, I don't want to plow ground we've already gone over, but do you know where that money goes that Rocky Mountain would collect from Midway City, for example, here, that wouldn't go actually into building this line, but would be some sort of surcharge on top?
Yeah, I mean, like I said, I'm not a finance expert here, but yeah, it's a surcharge on top of the project cost for the entire project.
But you don't know where that money goes, what it's used for?
No, I can't tell you exactly where it goes. It's just to account for internal costs is what I was explained by my finance group at a high level. It accounts for all internal costs of all the employees that are working here, whether they're finance, engineering, operations. They all lend some support to projects in maybe not a direct way on a project, but building that project, but they'll offer support. Like I asked for finance support on this project. I've asked for engineering support, for standard support. That's what those costs do, is recoup that from what I understand.
Okay. Thank you. Do the overhead project costs include a surcharge as well?
Yeah, all projects do.
All right. In the direct testimony, I think you testified that going overhead was going to be about $269 a foot. Remember that?
Yes.
That doesn't include the cost of right-of-way and easement. That's a pure construction cost.
That's pure construction.
And does that number include the surcharge?
No, that one did not. That was just comparison of construction.
Rocky Mountain doesn't insist on having spare conductors for overhead facilities, does it?
No. Not installed. We'll have, a spare reel in our operations or service centers to go pull in a conductor on an outage, but no, not installed.
But the bid on the overhead doesn't include costs for an extra conductor.
No.
Okay. You mentioned the bid meeting. Was that February 10th?
Yes.
Of this year?
Yes.
Okay, so just over a couple months ago. Jason Norland from Heber Light was at that meeting, wasn't he?
Yes, he was.
Okay. You said 4 of 18 showed up. You don't know why the 4th person chose not to put in a bid?
No, I didn't.
Was there any discussion in the bid meeting about the reality, if you will, of these bids? I mean, and by that I mean, was there a sense or a mood in there that look, we just want a number from you, but don't get your hopes up about the job being awarded, something like that?
No.
Do you know, Mr. Myers, why no bidders have been asked to come and testify about their bids in this proceeding?
No.
Did you tell these bidders, and maybe if it's in the papers, just tell me and we can look at it ourselves, but did you tell these bidders when they would have to have their work completed?
We put an in-service date in this project like all other projects.
And what in-service date did you give them?
December 31st, 2020.
Okay.
Well, it may have been November. It was the end of this year. It may have been December. I could look. It was the end of this year, though.
You would agree with me that sometimes if you tell a bidder they have to have a job done by a certain time, the cost may go up because they may need to devote more resources to get it done quickly. You're familiar with that? You're familiar with that dynamic?
Yes, they will add escalation costs to that project, but on this one they submitted schedules saying they would not be able to meet that date.
And so if the in-service date that if the in-service date that you had provided to these bidders had been out in 2021 sometime, even as late as the fall of 2021, you would expect their bids to have come in differently, wouldn't you?
Not necessarily. Like I say, they submitted a schedule that did not meet the end of this year. They put their schedule when they would be able to get this in service,
And
which
the
was into 2021.
the $12 million bid, what was the date they said they could get it done by?
I will have to pull that up. I don't have it in my mind. I know it was into 2021.
All three of them were into 2021?
Yes, correct. There wasn't anyone that was able to complete it this year.
Did any of them tell you that for a price they could get it done this year?
No.
Mr. Myers, do you have an explanation as to why there is such a difference between the high and the low bids here?
No, I don't. It's not unusual. Like I say, we receive on average 2 to 5, 6 bids, and they're I would say often there's kind of whatever you might want to call it, an outlier or whatever. There's a high bid that a lot of times you just don't pay attention to. Like on this one, we received 2 bids that were fairly close, 10 or 11, 12% apart, which is very common. And so, no, there usually is a high one. I wasn't surprised.
But by more than a factor of 100%, that's common?
Yeah, I don't know if I'd say common, but yeah, it does happen. And for whatever reason, yeah, we have bids that have a wide range.
And so it sounds like you're not the right person to ask why one bidder thought this would be so much more expensive than another one. Is that right?
No, there could be a number of factors involved.
None of which you're aware of.
Objection. He's asked and answered that question. He just gave you several reasons why. He answered the question, and then you just said he didn't give you any reasons. So I'm going to object to the question.
I'm going to sustain that objection. Mrs. Thad LeVar.
Just looking at my notes here. In your overhead cost, did you include easement and right-of-way? Was that something separate?
Yeah, that was separate.
Okay. You didn't have anything to do with estimating what it would cost to obtain rights-of-way severance damages?
No.
Okay. I think that's all I have for you, Mr. Myers. Thank you.
Thanks.
This is Thad LeVar. Thank you, Mr. Morris. Mr. Reich, do you have any redirect for this witness?
No questions.
Okay, thank you, Mr. Reich. Do any board members have questions for Mr. Myers? If you do, just jump in and let me know, and if 2 of you do it at the same time, I'll sort that out.
This is Troy Fitzgerald. I have a couple of questions, possibly.
Okay, why don't you go ahead? Okay, Mr. Fitzgerald, why don't you go first, and then we'll go to Mr. Clark.
I think I've got a question for the board first before I ask any questions. And this has troubled me since the beginning, since our first hearing on this. I'm just trying to understand the process and what our responsibilities are. In 54-14-305 2B4, we're to resolve a dispute regarding the apportionment of the actual excess cost of the facility between the local government and the public utility. And I mean, throughout the proceedings, we're hearing about, Rocky Mountain's a party, but we're hearing that roughly half of the costs are allocated to Heber Light and Power. And am I missing something, or it seems to me that the issue is between the cost Rocky Mountain is incurring as a result of the conditional use permit that Midway City's put in place, and Heber Light and Power costs should not be part of this. Can anybody help me with that?
This is Thad LeVar. Mr. Fitzgerald, did you want to direct that question to any of the parties first, or the council, or?
Well, I guess first, if that's our, I guess I'm asking first from the board is really, is a public utility include Heber Light and Power, and are they somehow a party to this? Depending on the answer to that, I'm happy to ask either the parties or the witness.
And this is Thad LeVar. I don't know that I have particular insight to add to your question. I'll see if other board members do, but then I think it's probably appropriate to see if the council for any of the parties want to give any of their views on your question. Do any board members want to make any comments in connection with this question from Mr. Fitzgerald? I'm not seeing any. Why don't I go to Mr. Wright first? Do you have any response to this question? I think it's probably a question for the council more than it is for Mr. Myers. So why don't we just go that direction for a few moments?
Yeah, this is Brett Reich with Rocky Mountain Power. I'm not prepared really to address that. I'd be happy to prepare something and submit it to the board. Also, we may need to confer and give Heber Light and Power an opportunity to respond to that question also.
Okay, thank you. Do any of the, Midway City, do you want to address the question at this point, or would you like to maybe give all of you an opportunity to address it later in the hearing?
I'll just do an overview, reserving the right to possibly amend. My understanding is there's an agreement between Rocky Mountain Power and Heber Light and Power to split the costs of this line 80% to Rocky Mountain Power and 20% to Heber Light and Power. Rocky Mountain Power is the only party who has challenged the conditional use permit. And so I think it's in the purview of this board to determine what the above ground costs are, what the below going underground with the easements, to determine what the actual excess costs are going to be. And then whatever those are, ultimately, they'll be split 80-20 between Rocky Mountain Power and Heber Light and Power. Heber Light and Power has not challenged the conditional use permit, so I think that any rights that they have will be dealt with contractually between Rocky Mountain Power and themselves. So I think that for purposes of what the board's trying to accomplish, there's not really separated out specifically Rocky Mountain Power costs versus Heber Light and Power costs. It's a joint process, and it's unique and a little goofy, frankly. But I think that based on what I understand, you need to determine what the actual excess costs are of the entire project, and then contractually, that will be dealt with between the two parties privately.
Thank you, Mr. Gordon. Mr. Morris, anything else to add at this point?
If that answered Mr. Fitzgerald's question, I wouldn't have anything to add.
Mr. Fitzgerald, why don't we go back to you? Do you want to do any follow-up, or? proceed
Yeah,
further?
I'll ask a couple of questions then while the witness is here, and I'll say that does raise significant questions for me about whether the facility should be constructed and how the cost should be allocated. But if the question for the witnesses are, what is the estimated cost of the duct bank being installed for the benefit of Heber Light and Power?
Can you repeat that? Sorry.
Sure. What is the estimated cost of the duct bank being installed for the benefit of Heber Light and Power?
Compared to these construction bids or total
Yes.
cost? We haven't figured that at this point yet.
Okay. Would it be fair to say that it's approximately half the total cost?
I wouldn't want to speculate at this point, as that hasn't been, accounted for or broken out yet.
Okay, so there are 2 duct banks?
Correct, yes. 2 duct banks, 2 separate circuits being installed.
One is for Rocky Mountain Power, is that correct?
Yes,
And one is for Heber Light and Power?
yes, correct.
Are there any costs associated with the construction that would only be for Rocky Mountain Power?
On this section of line, just what would directly be their circuit. That has to do with their circuit.
And then finally, based upon what you heard there, I mean, can you just confirm, well, I guess I'll ask it this way, is there a contract to divide the costs between Rocky Mountain Power and Heber Light and Power?
Yes, there is.
And do you know how those costs are divided in the contract?
I don't have the details on that.
Okay. Thank you. That's all I have, Mr. LeVar.
Thank you, Mr. Fitzgerald. Mr. Clark, did you have some questions for Mr. Myers?
Yes, I do. Mr. Myers, taking you back to the discussion of option 1 and the 6,990 feet of cable in relation to the 5,300 and some feet that would be in underground.
Right.
It seems I'm going to ask you whether or not it's a reasonable inference that the bidders that specify trenching for 6,990 feet misunderstood your specification.
It's possible. I do, in our summary of work here, we clarified the extra, 100 feet per phase at each termination structure to try to make that clear.
Right. But the bids reflected something different than that. And so I'm wondering, did that discrepancy become apparent to you as you reviewed the responses or the bids that were that came in response to the request for bidding?
No, no, it didn't.
I guess another way to ask that is, did you just become aware of that today?
No, I saw the number in there, and sometimes it's hard to interpret a contractor's bid. They will put costs in one line item and not in another. If you go through some of these, they'll have, more in one and some in another. And I don't have an explanation as to why they do that, but we see that often.
So if you've been reviewing these bids in a different context, a context where this was going to be a contractor providing the work for Rocky Mountain Power, but without regard to conditional use permit and the parameters of that, would you have inquired regarding that the discrepancy that you note today between what the bids say about the length of trenching and your specifications?
No, I don't believe I would have taken a different approach. I was treating this as if this is what we're going to build, and that's kind of the way I pursued this the entire time, as an underground transmission line.
I have no further questions. Thank you.
This is Thad LeVar. Thank you, Mr. Clark. Do any other board members have questions for Mr. Myers? I'm not hearing any, so thank you for your testimony today, Mr. Myers. Mr. Reich, you can proceed to your next witness.
The next witness would be Jason Norleen.
Okay, this is Thad LeVar. Before we go forward, we again have an objection to this witness. So why don't we go to Mr. Gordon, if you want to give any quick summary of your objection to Jason Norleen.
This is Mr. Jukes. I like making objections, as you can tell. But in this case, I think I'm going to withdraw my objection to Mr. Lorne. He's a great guy, and I want to give him an opportunity to testify today.
Okay, thank you, Mr. Jukes. Mr. Morris, anything for you to add? You had joined the motion. You had not independently objected to this witness, but you joined in Midway's motion. So do you have anything to add to the objection at this point?
I do not. If Midway is withdrawing its objection, I'll go along with that. Thank you.
Okay, thank you. Mr. Norlin, are you on the line?
Yes.
Do you swear to tell the truth?
Yes.
Okay, thank you. Mr. Reich, you can go ahead.
Sure, Mr. Norland, this is Brett Reich at Rocky Mountain Power. We're not in the same room, so have you had the chance to review your direct testimony that has been submitted in this proceeding?
Yes.
And is it an accurate representation of your testimony at this time?
Yes.
Do you have any changes to make?
No.
We would offer the direct testimony of Jason Norland.
If there's any objection to that motion, please indicate it. I'm not hearing any objection, so the motion is granted. Thank you. Okay, go ahead, Mr. Reich.
The witness will be Craig McKylis.
I'm sorry, are you finished with Mr. Norland, Mr. Reich? Are you finished with any direct questions?
Oh, sorry, yes. Sorry about that.
Okay, thank you. Mr. Gordon or Mr. Jukes, do you have any questions for Mr. Norland?
Yes, I do. Thank you. Morning, Jason. How are you?
Good. How are you doing?
Good, good. Just a couple of quick questions here. You've worked for Heber Light and Power for over 20 years, correct?
Yes.
How many times has Heber Light and Power lost power from the transmission line coming up Provo Canyon?
Several. I don't have
direct number, probably at least 2 or 3, that are, you know, kind of real outages, and then there's been several bumps, beyond that knock us
Okay.
offline.
Okay. So, and do you recall what caused those outages?
Yeah, I think there was an avalanche or something that took us offline. Probably a couple of springs ago. There's been some probably some wildlife issues, but we don't really get like the exact cause of the outage unless we really push. You know, our sales guy at Rocky Mountain Power, our customer rep, and sometimes they don't even know. So sometimes we're just left with, you know, just trying to deal with a transmission outage.
Okay. In the last 20 years or during your time at Heber Light and Power, how many days combined over that time has Heber Light and Power's system been down due to a loss of that transmission line?
As far as just down, I would say, you know, 2 or 3. But there's been several other instances where we've had to supplement that transmission line with various other means. And there's quite a bit of voltage issues that come in that we have to deal with as an end-use customer.
Okay, but just to clarify, over the last 20 years, collectively, power has been down maybe a couple of days, correct?
I wouldn't say in the last 20 years. I would say, you know, a couple of times in the last maybe 4 to 5 would be more accurate, I believe. 20, I'd have to really go back and look. So.
All right. What's the longest that you're aware of that you've lost power in that transmission line?
I think there was you know, I'm guessing that a few years ago we had about a 6 to 7 hour outage.
And on that one, were you able to supplement with sources within your own system?
No.
To cover the difference?
No, we weren't able to. So once the line trips and the generation trips offline, we're not really designed to island. It'd take us 2 or 3 days to get that to happen.
Okay. Let me just kind of glance through my questions here. Based on projections in your own company, the North Line, you currently are not saying that it would be overloaded until 2022, correct?
Can you restate that?
Sure. There was a load study done on your company that's been submitted to us, and based on my review of that, it stated that the North Line is not currently exceeding its capacity, correct?
No. No, the North Line can pack the system, yes.
Okay. And there's not real concern about the North Line through the year of 2022, correct?
Correct, yeah. North Line, it's in good shape.
Okay. And you run a looped system, meaning that you can rely on the North Line while the South Line is being upgraded, correct?
Yes, and other than a couple of just kind of weak areas where we cannot do that.
Okay. But the plan will be that the existing south line, the 46 kV line, will be decommissioned during construction, and you'll be relying on the north line, correct?
Yes.
And the north line has the capacity to deal with the system while the south line is down, correct?
Yes.
Okay. What is the realistic chance that the load capacity in the north line would be exceeded if the new line is not finished until spring of 2021?
We don't anticipate the north line load being exceeded within the realm of any of the studies we've done.
Okay. So if there were a scenario where Midway City was allowed to bond to Barry and the new line was pushed off on the Midway portion till the spring of 2021, you don't foresee a situation where that would harm your system or put people in a scenario where they would not be receiving power, correct?
I don't know what you're asking me there, Corbin. I mean, if a car hits a pole on the north line during peak, the south line can't handle our peak, so there would be an outage.
So, and that helps me to clarify. So short of, let me clarify better and ask that question better. Short of something that causes an outage on the north line, it can handle the load while the south line is being built, correct?
Yes.
Okay. And how many times have you had outages in the north line?
Not very often. I don't have that information right in front of me. I'm sure we've had a couple operations on that in the last few years.
But ever situations that lasted, say, maybe more than an hour where power was out on the north line?
Yeah, I don't think there's anything that was beyond like 2 hours. It'd probably just be like some type of an environmental event, like a animal wildlife type event.
Okay. So I'm just trying to assess the risk here. Is it safe to say that if the new transmission line is delayed, say, 5 or 6 months, that statistically the risk is not particularly high that the north line is going to go down in that time, correct?
I mean, we'd be relying on the north line, yes.
Okay, and that line's been very reliable in the past, correct?
Yeah, it's a good line.
Okay. Let me see here. Were you involved in creating the specifications for the bids that were sent out to vary the line?
Yes.
Okay. I just want to ask you a few things about each one of them. The bids require a dual trench to bury. Were you a part of that?
Yeah. There's two separate entities. Once we go underground, we got to remain separate.
And is that more for convenience, or is that based on any industry standard that you're aware of?
As far as I know, without diving into it, we did have this discussion with my engineer as we developed those specs, and it's my understanding that two companies can't share the same duct bank.
Okay, and that was based on a discussion with your engineer, correct?
Yes.
Okay. There's also a requirement in there where there's going to be an extra conduit installed, but also a specification that an extra line will be pulled through that conduit on both circuits, both Heber Light and Power and Rocky Mountain Power. And my question to you is, did you request that the extra line be pulled through?
With my engineers, yes.
Okay, and was that based on any safety requirement that you're aware of?
No, it was based on a reliability conversation that we had. It's a long lead time item, that wire, and the splicing is long lead time, and once you go underground, it just made sense to us to, you got the puller set up, everything else to get that spare cable in, and if not, we've got to buy it anyway and put it on our rate base, so we have it available because it's a long lead time item. Yeah, it was a conscious decision. I think I talked about it with the board, and it went into our spec.
Okay. Let me just look through if there's anything else that I want to ask you. I don't think there's anything that I need at this time, so I'll finish with the witness. Thank you.
Thank you, Mr. Gordon. Mr. Morris, do you have any cross-examination for Mr. Norland?
I do. Thank you, Mr. Chairman. Mr. Norland, my name's Mark Morris. I represent Volt. We met in a meeting up in Heber many months ago. I don't know if you remember me.
Yes. Yeah, I do.
You mentioned in your direct testimony that the existing line is at the end of its useful life. What makes that so?
It's been outgrown by just growth on the Heber Light and Power distribution system. So that, and that just a typical reconductor won't work on that line because of the age and condition of the structures themselves. And so that in itself made me make that comment that it's at the end of its useful life.
Okay, and how old is it?
Near as I can tell, it was built in the mid-70s.
So almost 50 years?
Yeah.
The line that is proposed to be built and go overhead, how long would you expect that line to be there?
I don't know exactly when it would be fully depreciated, but I'm guessing that it's good for 40 or 50 years, just like this one.
So whatever's put there, the residents living there can expect to see that for a goodly portion of their lifetime. Is that fair?
Yeah, I mean, there's a line there now. If that line gets rebuilt, then.
In connection with your working with Rocky Mountain, did you ever make any representations to Rocky Mountain about the width of the existing easements that run with your current line there?
No, I told them that I had a prescriptive easement that allows me to safely operate a 46 kV line.
And so you never gave them dimensions?
During those initial talks, I don't recall ever talking to them about dimensions. They're in the utility world and they know what a prescriptive easement is.
Okay, that's fair. I just wanted to make sure you weren't the source of any information that they obtained that would lead them to believe there were, for example, 60 or 57-foot wide easements along the current HLP line. Nothing like that came from you, correct?
No, we have a prescriptive easement to safely operate a 46 kV line. So whatever width that requires, you know, we never really talked about width. I got through this process, some widths have come up, but that sound reasonable to me. By the time you get a truck in there to replace a pole, or you know, you have a weather event that blows a line down, it's going to take, you know, 20 plus feet on either side to get in there and get that line fixed.
And to date, Mr. Norland, I mean, you've seen the line recently, haven't you?
Yeah.
It's fair to say, isn't it, that there are structures, trees, even a tree house that are less than 20 feet away from your lines?
Yeah, I'm not disagreeing with that.
If a landowner, for example, were to testify that they've got vegetation going right up against your poles and very close to your lines, less than 5 feet, you wouldn't dispute it, would you?
No, but if I needed to get in there and remove that in order to safely operate that line, then that prescriptive easement would give us that right.
Have you ever had any discussions with anyone at Rocky Mountain Power about going underground versus going overhead? I mean, do you personally have a preference here?
No, I want to get the project done. That's what I want to do. You know, if it ends up going underground, let's do it. So,
what facilities has Heber Light and Power already agreed to bury in connection with the Jordan Eldon Midway project?
We're already burying all the distribution.
All of it?
All of it through this section that we're talking about. So we've agreed, and the board's agreed to put all underbuilt distribution and also put conduit in the ground to allow for the communication cables to come off the current transmission line as proposed.
And so that expense is already being borne by Heber Light and Power to build at least one trench through this line?
Yes, that's all going to get rate-based, yes.
Okay. And what size, do you know what size of a trench is already going to be dug here?
Yeah, it's going to be enough to accommodate that distribution underbuild. It's going to be different in places. Some of that's three-phase, and other sections of it are single-phase. So that'll just vary as we take that distribution off.
And what are the dimensions? I'm sorry, I think I probably know less about the tech stuff here than anyone. When you say a single or a triple, what dimensions in feet are you talking about?
When we go underground with it?
Yeah.
It'll be, probably a 3-foot trench that's, 3.5 feet deep. We need to have 3 feet of cover over that. So.
Okay. That's helpful. Thank you. Are Heber Light's facilities in Midway the only ones being buried, or are you going underground along the whole route?
The Facilities Committee of the Power Board determined where we were going to take it underground. And I think in just all of the residential areas, I know in Heber City, we're taking everything underground. And then through certain parts of Wasatch County. I think the only place where we stayed distribution overhead is from the proposed point of delivery substation to Highway 113 in Midway.
Okay. Is Heber Light and Power issuing bonds to pay for underground relocation?
Yes. That's been done.
Is Heber Light and Power going to own or operate any of the 138 kV transmission lines being buried by Rocky Mountain Power?
No, we're not going to operate any of their circuit.
Okay. The last topic I want to go through, you attended on February 10th the meeting of bidders for the underground proposal to go through Midway. Is that right?
Yes.
And you reported on that meeting to the board at a March 4th meeting. Do you recall that?
Yeah.
Just a month and a half ago?
Mm-hmm. Yep.
Do you remember telling the members of the board in that meeting that a lot of the meeting with the bidders was trying to convince them that it was worth their time to put in a bid? Correct?
Yeah, those questions came up in that bid meeting as to how realistic this project was, and I told them that we had a city that was more than willing to pay for this line to go underground based on a survey that was done.
And there was some hesitancy in the contractors that you sensed?
Initially, yeah. I thought that when they came in, they asked pertinent questions. I would have asked the same questions.
Did you ever have any conversations with any bidders that decided not to put a bid in for any reason? I mean, anyone who received the RFP but who chose not to put a bid in?
No.
All right. I think that's all I have for you. Thank you, Mr. Norland.
Yep.
Okay, this is Thad LeVar. Thank you, Mr. Morris. Mr. Reich, any redirect for Mr. Norland?
Yeah, just two questions, Mr. Norland. Are there any questions that you've been asked that you haven't been able to give a full answer to, or that you would like to clarify?
No.
Okay, and then my other question is, Mr. Morris asked you about the length, or how long this line has been in question, and I think you said approximately 50 years, and he also asked you about some trees and things that have grown into the line. I understand you've worked for Heber Light and Power for 23 years. How has the development around the line changed over the years?
Quite a bit. So when I first started working there, the line was mostly through fields, and since that time, there's been some development on Ward's Lane and also down on the other portion of the line. They're on Stringtown Road. The houses to the east have been there for a long time.
I have no further questions.
Thank you, Mr. Reich.
I'm sorry.
Is this Mr. Morris?
Yes.
Let me first ask Mr. Gordon Mr. Gordon, do you have any questions based on that redirect?
Just one to clarify.
And then
Jason,
before you go forward, before you go forward, Mr. Morris, am I understanding that you also you have some recross?
I do. Thank you, Mr. Chairman.
Okay, why don't we go to Mr. Gordon first, and then we'll go to Mr. Morris.
Thank you. Just one question. Heber Light and Power isn't challenging the conditional use permit, correct?
No, we'd just like to get some finality to it so we can keep the project moving.
Very good. That's everything I have.
Thank you, Mr. Gordon. Mr. Morris?
Thank you. Mr. Norland, in response to Mr. Wright's question, you mentioned that there's been a lot more development over the years near this line. By that, do you mean there are more residential properties and families that are living closer to this line than there were previously?
Yeah, there's quite a few homes that have sprung up over there in that Ward Lane area. So, you know, that developer could have buried that line at that time too and chose not to. You got a bid.
Mr. Chairman, I would just move to strike the last part of that answer. It wasn't responsive, and I don't know where it came from. I don't want to go down a whole new path about decisions developers made or bids that were made.
Mr. Reich, do you want to respond to the motion to strike?
Yeah, I think it was responsive to his question, so we would oppose that motion to strike.
I think I'm inclined to agree that it was within the scope of the question asked. So I'm not inclined to strike. If any board members feel differently, please feel free to interject. But at this point, that's my ruling.
But I'd like an opportunity to follow up, Mr. Chairman.
Yes.
Mr. Norland, you said that the developer had an opportunity to bury the line. What line are you referring to?
The section of the line there by Ward Lane, when that subdivision went in years ago, we put together a quote back in that time for that developer to bury that 46 kV line. And he, or that company, decided not to bury that 46 kV line down Ward Lane.
So the developer would have had to have shelled out more money to bury the line, wouldn't he? Or she?
Yeah. Yes. Yeah.
Okay. So they elected not to spend the money to bury it.
Yes.
All right. That's all I have. Thanks.
This is Thad LeVar. Thank you, Mr. Morris. Do any board members have questions for Mr. Norland?
Yes, this is Glenn Wright. I have a question.
Okay, why don't you go ahead?
Mr. Norland, have you been briefed by Rocky Mountain Power on the public safety power shutoff plan?
Yeah, the wildfire plan?
Yes. Yep. Yeah, the one on wildfire.
Yes.
And can you tell me how that would affect Heber Light and Power operations?
Yeah, that's one of the real motivations of this since that came out, is that's clearly in their zone that they've identified as a line that could be de-energized if weather conditions are right, as well as the lines coming up Harley's Canyon. So they've given us notice that if weather conditions are right, there could be extended outages on those lines.
Okay, and since this is a summer event, are you comfortable with multiple summers going by before this line gets built?
No.
Okay. One more question on, has Midway approached Heber Light and Power, and do you have the ability to do a revenue anticipation bond for Midway customers?
There was discussion in a board meeting about that. I think the question still lies as to what exactly that dollar amount ask is going to be for the board. That's kind of how I understood that discussion going at the board level.
Okay. And if that decision was made by the board, how fast could that be executed?
Oh, it'd probably take 3 to 4 months to probably get that bonding done. Maybe a little bit less than that, but I'd say 3 to 4 months.
Okay, thank you. That's all my questions.
This is Thad LeVar. Thank you, Mr. Wright. Do any other board members have questions for Mr. Norland?
This is Troy Fitzgerald. I have a few.
Okay, go ahead. Thank you.
Thank you. Mr. Norland, can you explain the cost-sharing arrangement you have on this project with Rocky Mountain Power?
We have a construction agreement with Rocky Mountain Power to build a dual circuit overhead line. So, and under that agreement, they pay 80 on just 138 on one side, 46 kV on the other side. It's paid 80% Rocky Mountain Power, 20% Heber Light and Power. And then if there's any type of betterment, meaning need to upgrade poles for distribution underbuild or things like that, then Heber Light and Power pays for that betterment.
Will that arrangement change if the decision is made to take the line underground?
It could. The construction agreement is for an overhead power line.
And just so I understand, you were talking about taking your distribution underground. If the 138 kV line is installed underground, will the distribution lines be in a separate trench or in the same duct bank that's being constructed?
We would have to work with that. We've got RFPs out right now, so it would be a different contractor. So I'm guessing that we'd have to correlate that. I don't see them being in the same trench, just because I don't want my distribution line necessarily right next to my transmission line when it's in the ground.
And then I think my last question is whether it's above ground or underground on your transmission lines. I'm understanding there are 2 circuits being built. Is there ever a time Rocky Mountain Power would be using or operating your circuit?
No.
And vice versa, I guess you would never use or operate Rocky Mountain circuit.
No, they're 2 completely different company-owned circuits. So they would not have any control of mine, and I would not have any control of theirs.
Thank you.
Okay, this is Thad LeVar. Thank you, Mr. Fitzgerald. Mr. Clark or Mr. White, any questions for this witness?
I have no questions. This is Mr. White.
Okay, thank you. And I'm not hearing any from...
Clark, no questions.
Okay, thank you, and I don't either. Thank you for your testimony, Mr. Norland.
Okay, thanks.
And I think we'll take a break before the next witness, but let me cover a couple of housekeeping issues before we do that. Just to let everyone know, I'm not aware of any time constraints on board members today. We do have one tomorrow. We need to finish by 3 p.m. tomorrow for one board member's commitment. So So just so you know to plan for that tomorrow, but I'm not aware of any today, so I think we'll plan to go through the full afternoon today. And then just to circle back, based on the board discussion, I think it was the intention of the board that I provide to parties the sections of the NESC code. I have that in front of me and I can scan it during the break and email it to the parties. I would probably just respond to the email string that started last night with Mr. Reich. But I'm just going to confirm my intentions that I intend to scan and send out sections 320 and 352. Those were the two that were referenced in the email. So that's my intention during the lunch break, is to scan and email sections 320 and 352. And then if there are any other motions with respect to that as we move forward, we'll deal with those as we go. With that, I think we're ready to take a break. Does anyone else have anything they'd like us to address before we take a recess?
This is Mr. Morris, Mr. Chairman. For scheduling purposes, because we've got witnesses that need to get on a phone, can I inquire about how much time Rocky Mountain anticipates for its remaining witnesses, who it's going to call next, and then I'd like to know from Midway what they think their timing is on their witnesses.
Sure, this is Thad. Before I turn to them, I mean, we have two remaining witnesses for Rocky Mountain Power. I think the time that they will take depends a lot more on cross-examination than on anything from Rocky Mountain Power. But with that, Mr. Reich, do you have any additional insights? We have objections to both witnesses to deal with as well.
I agree with what you said.
So who's next? Is it Mr. Lefevre or?
No, we were going to call Mr. Michaelis next, and then Ben Lefevre after him.
Okay. And then once we're done with Mr. Lefevre, who does Midway? I mean, it sounds like we're going to get to someone else today.
Yeah, so you're asking Mr. Gordon or Mr. Jukes who they intend to call first? Is that your question, Mr. Morris?
Yes, thank you.
Yes, at this point, we would look to call John Nelson, our expert.
Okay, Mr. Morris, is that enough for now?
If we think that'll get us through the day today, yes.
Well, I'm not certain. We might get farther than that, but I don't know if Mr. Gordon, do you know who you would call second, or does that depend on anything that might happen between now and then?
Well, yeah, I mean, I don't foresee us getting to our expert. If we've got two more plus our expert, I think that's going to fill the day. So I would not foresee us calling any other witnesses today. I think that will fill it.
Okay, that helps. Thank you.
Okay, with that, I think we will recess until 1 p.m. Thank you. We're in recess. I'm sorry, this is Thad LeVar. I had my mute button for the last moment or two. Rocky Mountain Power had indicated that their next witness was Mr. Michaelis, and we have an objection to that witness from Midway City. So why don't we go to Mr. Jukes or Mr. Gordon if they want to address their objection to the witness?
We withdraw that objection.
Okay, thank you. Mr. Morris, you had joined the objection. Do you have anything to add at this point?
I do not.
Okay, thank you. Mr. Reich, is Mr. Michaelis on the line?
I believe so. He is not here with us, though. So, Mr. Michaelis,
Yes,
are you out
I
there?
am on the, yes, I'm on the line.
Okay, Mr. Michaelis, do you swear to tell the truth?
Yes.
Okay, Mr. Reich, go ahead.
And is it Michaelis or Michaelis? I apologize.
Michaelis. You're
Okay,
fine.
Mike. Have you had an opportunity? Okay. Have you had an opportunity to review your direct testimony that has been prepared and submitted in your name in this proceeding?
Yes.
And is it an accurate reflection of your testimony?
Yes.
Do you have any changes that you need to make at this time?
No.
Okay. Move to submit the testimony of Mr. Michaelis, sorry.
This is Thad LeVar. If any party objects to the motion, please indicate your objection. I'm not hearing any objections, so the motion is granted. Thank you.
And I have no further questions. Rocky Mountain Power.
Okay, thank you, Mr. Reich. Mr. Gordon or Mr. Jukes, do you have any questions for Mr. Michaelis?
Yes, just a few. Mr. Michaelis, number one, you're an electrical engineer, correct?
Yes.
And you performed a load study that for the Heber Light and Power system that you've attached to your testimony, correct?
Mac Fillingham actually performed the study. I supported him and reviewed his results.
I see. Fair enough. The analysis was solely on Heber Light and Power system, correct?
Yes.
On page 7 of the report, it states that the ability of Pacific Corp to be able to provide power to Heber Light and Power during peak loads or outage conditions was not studied, correct?
Correct.
Okay. In your analysis of Heber Light and Power's system, you analyzed the system in both 2018 and in the future in 2022, correct?
Yes.
And in one of those scenarios, you analyzed what would happen to the system in 2018 if the south line were lost, correct?
Yes.
And your 2018 conclusion, if the south line was lost, is, quote, there are no issues running with this outage, correct?
Correct.
And so that means that the north line has the capacity to operate the system while the south line is down, correct?
Correct.
And your conclusion regarding the loss of the south line in 2022 was the same, namely, there are no issues running with this outage, correct?
With the north line carrying the load, correct.
So, based on your report, the new line, the replacement line in the south, could be installed in 2020, 2021, or even 2022 without creating risk of overloading the north line, correct?
In respects to the north line, correct.
Okay. So, in theory, the bulk of the new transmission line could be built in 2020 or 2021 with the small portion of the Midway line buried in the spring of 2022 without overloading the north line, correct?
Just for
Correct.
clarification, Just for clarification, when you say the transmission line, could you clarify what transmission line you're talking about?
Oh, I'm sorry. So the replacement line, the south line that we're talking about, that is the focus of this proceeding, the dual circuit 138 kV line. So
It's a 40
with that,
kV line.
yeah, the south line is currently a 46 kV line, correct?
Yes, correct.
Okay, and based on your testimony, that line could be decommissioned and remain out of commission, and the north line could carry the load through the year 2020, 2021, or 2022, correct?
But you would not have any backup to the north line.
That's not what I asked you. I just said that
But you are correct. Yes.
Okay, very good. And your analysis, you are not in a position to state anything about anything regarding Rocky Mountain Power System or any impacts or capacity of Rocky Mountain Power System, correct?
Correct.
No further questions.
Thank you, Mr. Gordon. Mr. Morris, do you have any questions for Mr. Michaelis?
I do not. Thank you.
Okay, thank you. Mr. Reich, any redirect?
No, we have no further questions.
Okay, thank you. If any board members have questions for Mr. Michaelis, please indicate that you do. I'm not hearing any questions. So, Mr. Michaelis, thank you. Oh, sorry. Go ahead.
This is Dave Clark. I have a question. Mr. Michaelis, you mentioned that the north line would operate, but without backup in your last response, if I heard that correctly. And is that a normal operating condition for a transmission line?
No, you would want to have a backup source in case you have an issue with the north line.
That concludes my questions. Thank you.
Thank you, Mr. Clark. Do any other board members have questions for Mr. Michaelis? I'm not hearing any, and I don't. So thank you for your testimony today, Mr. Michaelis.
All right, thanks.
And Mr. Reich, your last witness is Mr. Lefeva. Am I pronouncing that right?
I believe it's Mr. Lefevre, and we do have one issue. He's about 15 minutes out, so I apologize for that. We didn't expect that last witness to go so quickly, so I don't know if we want to, if Mr. Nilsson's ready, but Mr. Lefevre is probably not going to be here for another 15 minutes.
Well, before we make a decision on that, why don't we deal with the objection to his testimony? And let me go to Mr. Gordon or Mr. Jukes first. Do you want to give any verbal summary of your objection?
Certainly, and this is Mr. Gordon. Mr. Jukes will be taking care of that. I do have one housekeeping item after we deal with this that I would like to bring to the Commission's attention.
Okay, we'll come back to that after we deal with the objection. So, Mr. Jukes?
So our objection to Mr. Lefevre's testimony, he's offered as an expert. We're not objecting to his credentials. He may well be a certified appraiser. It's more of an issue of reliability in the application of the law to his conclusions. We believe that his opinions lack foundation. They are obviously based on hearsay, and we don't think that they meet the requirements of Utah Rule of Evidence 702. For those board members who don't know what that is a rule that governs the admission of expert testimony as opposed to recipient fact witness testimony. And there's certain requirements that the opinions have to be reliable They have to reliably apply the facts to what's going on, and they have to be generally accepted in the relevant scientific community. Normally a court, in this case this board, would have the gatekeeping function of determining whether the expert testimony should be heard, depending on its reliability. One of the major issues we have is that Mr. Lefevre relies on an appraisal report. That's really the only evidence he has for any of his opinions, and he admits in his testimony on direct that he was not really involved in the preparation of that report. He said, quote, minimally involved. It was created by other people. Those witnesses are not available and not here. They're the ones who have personal knowledge about what underlines the report, what was done, about the formulations, the calculations, and different things like that. So that's a significant problem, and we think it makes Mr. Lefevre's testimony inadmissible. And we cited some case law in there that the board may want to look at, but also there's a lack of specificity. I mean, there's very general conclusions in the report. There were no actual properties examined. So none of these guys went out, the people who actually prepared the report, much less Mr. Lefevre, went out and looked at the properties we're discussing. These were just based on general real estate principles. To be frank, it's not really clear what they were based upon. It was based upon unknown sales, unknown owners, very, very general stuff. We just believe, Your Honor, that this indicates a real lack of reliability here, and that this board has a duty to examine that and to reject it in its gatekeeping role. Thank you.
Thank you, Mr. Jukes. Do any board members have any questions for Mr. Jukes at this point? I'm not hearing any questions for board members. I just want to ask, Mr. Jukes, to what extent are these issues that could be developed through cross-examination versus an action by the board to simply exclude the testimony?
Well, that's a very good question. And sometimes the line between something needing to be excluded or going to the weight of the credibility of the report can be blurred. But we think that in this case, there is so much unreliability that it's not appropriate to even hear the testimony based upon this report that has no foundation and is hearsay and appears to lack any independent basis. So in some cases, I think it's fair for us to ask Mr. Lefevre, well, you didn't prepare this, did you? You don't know what really happened. I mean, that would go to the weight of his testimony. But there's also a point where there's just minimum standards of reliability, and we've articulated those in our brief, and we just believe that Mr. Lefevre's opinions don't reach that minimum standard.
Thank you, Mr. Jukes. Mr. Morris, do you have anything that you'd like to add to this objection? You joined in it, and you also had your own independent objection before Midway City filed theirs. So if you have anything to add, please go ahead.
I think Mr. Jukes has summarized it well. Our main concern is Mr. Lefevre acknowledges expressly he had minimal involvement in the report, and it's the report that is the essence of what Rocky Mountain is proffering here. And so, again, the board and the parties are prejudiced because we do not have an opportunity to cross-examine the people who did put the report together and as to their methods. And because of his acknowledged minimal involvement in the report, yes, in answer to your last question, Mr. Chairman, I would expect all of us are going to bring this out in cross-examination, but when the witness has admitted to his own lack of foundation and lack of involvement, it seems like a waste of the board's time to go through the process of having all of that pointed out in cross-examination. Thank you.
Thank you, Mr. Morris. Do any board members have questions for Mr. Morris at this point? I'm not hearing any questions, so Mr. Reich, do you want to respond to the objection?
Sure. So as stated in the testimony that both counsel just referred to, he did state that he was minimally involved in the preparation of the report. He did also say that it was completed primarily by Eric Leonard and Troy Lunt, who are his two associates that work in his office. The next sentence says, I've read the report, discussed it with both Mr. Leonard and Mr. Lunt, and I agree with the findings. In addition to that, Mr. Lefevre signed the report. It's prepared by him. His name's identified on the first page of the report. Those things are all important because in Rule 702, which talks about the testimony of experts that Mr. Jukes referred to, the board does serve the gatekeeping function here to determine if expert testimony is reliable based upon sufficient facts or data and have been reliably applied to the facts. If you look at Rule 702C, it says the threshold showing required by paragraph B is satisfied if the underlying principles or methods, including the sufficiency of facts or data and the manner of their application to the facts of the case, are generally accepted by the relevant expert community. So the idea that a real estate appraiser would use somebody in his office to assist in the reports or to go out and look at properties is generally accepted in the expert community of real estate appraisers. It's a standard occurrence. If you look at Rule 703 that talks about the basis of an expert's opinion testimony, it says an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data informing an opinion on a subject, they need not be admissible for the opinion. So, I mean, Mr. Lefevre is going to be here, he's still not here. He's going to be open to cross-examination. So we think that it meets the requirements, that this is reliable. He did assist in the preparation. He talked to his partners and is familiar with the report and is prepared to respond to any cross-examination questions. Therefore, I think it is admissible under the rules of evidence.
Thank you, Mr. Reich. Do any board members have any questions for Mr. Reich at this point? I'm not hearing any questions, so I'll give Mr. Jukes and Mr. Morris an opportunity if they want to make any final statements before the board considers this. Mr. Jukes, why don't you go first?
Okay, this is Mr. Jukes. Just very quickly, I understand Mr. Reich's position here. I do think that it's not standard in the industry to have someone else prepare the entire report and the expert who's supposed to testify, who was retained for that purpose, to come in at the end and say, oh, okay, I've read your report and I agree with it, when they've not done any of the underlying analysis. I do agree that it's very common to have associates in an office help prepare a report, but in this case, it looks like, according to his testimony, that he wasn't involved in the actual preparation. After it was done, he discussed it with it and said, yeah, this looks good. Well, I think that's one of the major problems. I also just caution this court, clearly, this board, clearly you can rely upon hearsay. You can admit it. You don't have to, but you can. But you can't solely rely upon it. And in this case, it is hearsay, and it is the only evidence before this board of the cost of the easement. I know it's not actual cost as it should be, but it's some estimate of the cost, and it's the only evidence. So in relying upon this, I think the board is in jeopardy of relying solely upon hearsay.
Thank you, Mr. Jukes. Mr. Morris, anything further?
No, I agree. I don't have anything to add.
Okay, does any board member have any comment or further discussion before we get a ruling on this? I mean, this is Thad LeVar. I'll just state my inclination is to deny the objection. I would like to hear the cross-examination of this witness, and I would like to hear his response to some of the issues that are raised as we consider what weight we give to his evidence. I don't think it benefits our fact-finding if we exclude ourselves from the opportunity to hear his answers to those cross-examination questions. So I'm inclined to deny the objection unless I hear any other board members who want to propose a contrary route. And I'm not hearing anything. So the objection is denied. Mr. Reich, is he ready to be sworn in, or do we still have a few minutes until he's available?
Yeah, he has not arrived yet. I apologize for that.
Why don't we take a 10-minute recess then and just return at 1:30?
Actually, Commissioner.
Oh, you had an issue. I'm sorry, Mr. Gordon. Why don't you go ahead with your issue?
Yeah, this should be very brief. First one, just a discussion on exhibits. It's my understanding that the parties have stipulated that all of the exhibits that they have submitted to the court are deemed admitted unless specifically objected to. I want to clarify that so that we don't go through a long process of trying to admit all of those. That's my understanding. I wanted to ask the other counsel on that and make that part of the record so that everybody's clear on what it is that has happened with the exhibits.
That is not my understanding. This is Brett Reich at Rocky Mountain Power. I don't recall agreeing that all the exhibits submitted. For example, I understand that the Midway City just provided some demonstrative exhibits, but we have not seen, haven't had a chance to look at to determine if they have any relevance or what they are. So I don't recall that we all agreed that everything submitted would be automatically admitted into evidence.
Mr. Morris?
Well, it was my hope, too, that we wouldn't have to go through a laborious, time-consuming process of laying foundation and doing all of that. In my review of the exhibits, they all appear to, nothing appears to be fabricated or false I suspect, given the board's prior rulings on admission of evidence, that all of this is going to have some bearing, and it's going to be a matter of weight. And so I'm willing to stipulate to the admission of everything that's been submitted by all the parties so far, with the exception of the objections we've already lodged as to witnesses that haven't been the real people on the ground for lack of foundation.
And can I give just one thought on that, Commissioner?
This is Mr. Wright?
No, this is Mr. Gordon.
Oh, Mr. Gordon. Yes, go ahead.
Yeah, and I guess this would be in response to Mr. Reich. Based on my understanding, there would be problems if we don't proceed that way with some of the evidence that you've purported to rely on, because I don't believe you've laid the foundation necessary to have many of the things that your experts have relied on admitted in the record. So I just want to clarify where we are here and what's happened, because I think, in fairness, that was my understanding. I'm not objecting to you having your witnesses testify to those things that were attached to their testimony, but I don't think that the appropriate foundation was laid if that's the way that we're going to do this.
Do any board members have any questions for any of the attorneys at this point?
This is Dave Clark. I just want to make sure we're not talking past each other, because I understood the initial proposal to refer to exhibits and evidence that as to which a specific objection is not lodged. And I didn't hear that qualification in Mr. Reich's statement. So I just want to make sure that that all the parties are talking about the same issue.
Do any of the, well, let me go to Mr. Reich first. Well, probably Mr. Gordon first. Do you have any comment on Mr. Clark's clarification or question?
Well, I agree with him. That was my proposal, is that unless I'm not trying to give carte blanche to all parties to just bring in whatever they want if there's no foundation to it. But what I'm proposing is we can all assume that anything submitted by any party will be part of the record unless objected to, which I think is a very good way to proceed. And I think his understanding of that is correct.
Mr. Reich, does that impact your objection to the motion or request?
I guess what the part that's ambiguous or confusing to me is that when you say submitted, are we talking about right now during this proceeding? Because I believe that during the testimony of our witnesses, we've asked to submit the documents that they relied on. Or are you talking about documents that are filed with the commission? For example, I understand that Midway City recently, over lunch, filed some exhibits that we haven't had a chance to look at. So if are they saying that those are automatically admitted? Then that's my concern. If there's a document we haven't had a chance to look at or see, well, yeah, I'm not trying to say, certainly I understand that most of the documents are coming in. I'm not accusing anybody of anything false. But I just want to be able to make sure I have the right to look at something before it gets admitted into evidence. That was my point.
Absolutely. And so let me clarify. Yeah, that's we had just overlooked a few things on our expert. We have submitted those fully. Would say that you would have the right to object to those and say we want an opportunity to review those. So I'm not proposing to take away your right to object to something. I'm just saying rather than going through the formalities of having everything submitted, we can assume if it's been submitted, it's part of the record unless you object.
Okay, do any other board members have any questions for the parties on this issue? Board discussion. Any comments from board members? Well, I'm not hearing any comments, and it does seem like this is probably the most efficient path forward that still preserves every party's right to object to any exhibit. So unless I hear anything different from the board members, my intention is to grant the request by Mr. Gordon to treat all filed exhibits as entered into evidence unless objected to. And I'm not hearing anything else from board members, so that request is granted. Thank you, Mr. Gordon. Mr. Reich, are we ready for your witness now?
We have managed to take enough time that he is now here.
Okay, thank you. Mr. Lefevre, do you swear to tell the truth?
I do.
Okay, thank you. Mr. Reich, go ahead.
Mr. Lefevre, have you reviewed the direct testimony and the rebuttal testimony that has been prepared in this proceeding and submitted in your name?
Yes, I have.
And do you have any, is it an accurate reflection of your testimony at this time?
It is, yes.
Do you have any changes to make?
No.
I'd move to submit the direct testimony and the rebuttal testimony of Mr. Lefevre at this time.
Okay, thank you. This is Thad LeVar. Recognizing the ongoing objections of both Midway City and Volt to Mr. Lefevre's testimony, are there any additional objections to the motion to enter his testimony into the record at this point? And I'm not hearing any, so the motion is granted. Thank you.
We have no further questions.
Okay, thank you, Mr. Reich. Mr. Gordon or Mr. Jukes, do you have any questions for Mr. Lefevre?
Yes, Mr. Gordon will conduct the cross-examination. Good afternoon, Mr. Lefevre. Thank you for joining us.
Hey, good afternoon, Mr. Gordon. Is that correct?
Gordon, yes. Thank you.
Perfect. Thank you.
So just overview here, you were minimally involved in the preparation of the report, correct?
Yes, that's correct.
You reviewed it with Eric Leonhardt and Troy Lunt, correct?
That is correct, yes.
Okay. In your report, you did not identify values for each one of the impacted properties, correct?
Correct, yes.
You took an overview of sales of similar properties in the area, and based on this analysis, you came up with a range of value for the impacted properties, correct?
Correct.
A more accurate value could have been obtained if an appraisal of each impacted property was done, correct?
I haven't done an appraisal of each impacted property, so it's hard to comment as to the accuracy versus the range we provided. A more robust appraisal could have been completed.
Okay. And do you feel that if you had done an appraisal on each property, it would have been more accurate?
Again, difficult to comment to value accuracy since I haven't done that appraisal.
Okay. And you indicated in your report that a property-by-property analysis of the impacted properties was, I believe, quote, outside the scope of the work, correct?
Correct.
Okay. And in your report, you stated the scope of this assignment is somewhat unique in that we do not estimate market value for a specific property or properties, correct?
Correct.
So the study gives a range of value of what the easement costs might be, correct?
Yes, based on land values.
Okay. But you have no information on what the actual costs of the easements will be, correct?
Correct.
The only way to establish what the actual costs would be is if Rocky Mountain Power reaches a settlement with an impacted property owner or condemns a property owner, correct?
Correct. Yeah, appraisals are always estimates, yes.
Okay. And to your knowledge, none of the easements have been obtained at this time, correct?
To my knowledge, that's correct.
Okay. On page 3 of your report, you indicate that your conclusions were based on interviews with buyers of easements. Who did you talk to?
Specifically for this assignment, I didn't reach out again to anyone. We, over many years, have interviewed acquisition agents at many of the groups that procure these type of easements, Rocky Mountain Power, Questar, that's a lengthy list. In addition, I've done work a number of times for different subdivision builders and home builders as they acquire these easements in their subdivision developments.
But on this specific report, did you talk to any of them?
No, not for this specific report again, no.
Okay. You relied on 26 sales and listings in the Midway area, correct?
Correct.
None of the properties you looked at had homes on them, correct?
Correct. We were looking at land only.
Yeah, so you were trying to establish the value of raw land in your analysis, correct?
Of land. That raw word means different things to different people. I would say land that didn't have significant vertical improvement. Maybe that's a better classification.
Thank you for that clarification. So many of the impacted properties either already have homes built or will have homes built on them, correct?
Possibly. We'd have to, look at each of those impacted properties individually. As I mentioned, I've not looked at each of those individually to perform separate appraisals.
Okay, so you're not aware of how many of the impacted properties actually have homes on them?
I'm aware of homes. Maybe the better way I should put that is I'm not aware of how many of those homes might be impacted.
Okay. Now, are you saying, based on your analysis, that existing homes should not be taken into account when considering the value of the easement?
No, not at all. I'm saying that the value, maybe that's a better question as to, by value of the easement, do you just mean the easement to be acquired? If that's the case, then yes, the home would not come into question in terms of the easement over the land area to be acquired. Value of the home or the impact to those improvements may come into question in terms of an after value, but it would not be a part of an easement to be acquired over land.
So it's your testimony then that an easement coming across a property with an existing home, the appropriate professional way to establish the value is simply to take a measurement of the width of the easement and do nothing to take into account the impact that will have on the existing home. Is that your testimony?
Maybe. What do you mean by value of the easement? I mean, we kind of get into obviously, in eminent domain valuation or valuation under the threat of eminent domain, which is the typical, the way I would describe this type of typical analysis. You're going to analyze the property in the before condition, and then under the state rule, you would analyze the part to be acquired and determine the value of that part to be acquired. In this case, if only an easement is to be acquired, the improvements do not come into question for that value of the acquisition. The improvements would only come into question for the value of the larger parcel in the after condition.
Okay, so just once again, your analysis is that you looked at simple ground value, measurements of ground, and did not take into account any value or diminished value on existing homes that this easement might impact, correct?
That's correct.
Okay. Now, in your analysis, you include a range of values that go from 25% to 75% of the underlying land value, correct?
For the value of the easement, yes, as a percentage of fee.
Okay. And while you give a range of values, your report does not opine on what the actual percentage of value should be for each of the impacted properties, correct?
Correct.
So, for example, on page 15 of your report, on the first parcel listed, which ends in 4611, the value of the easement could be anywhere from $68,750 to $243,750, correct?
Value, that's on a price per acre basis. So it wouldn't, depending on the square footage there of that easement, but on a price per acre basis.
Yes, and I believe, so it would range from 25% to 75%, right?
Yes.
Okay. Now, there are any number of things that could affect the actual value of the easement that is unique to this property, correct?
Correct.
And that's including impact on existing structures, destruction of existing landscaping, driveways, et cetera, correct?
No. Again, the existing structures would not go into the value of the easement over the land. That only comes into impact in an appraisal in the value of the larger parcel in the after condition.
Okay, so you're saying that the value would not be altered in any way if there's existing structures in the way or existing landscape or driveways that have to be removed?
The value of the easement, no. Again, in this type of valuation, you identify the larger parcel, estimate the value in the before condition of that larger parcel, estimate value of the part to be acquired. In this case, the parts we're discussing would be an easement over land only. So that easement value would be just the value of the easement over the land, and then the value in the after condition of the remaining larger parcel is estimated. That would be where any impact to the improvements would come into play.
I see. Do you think that the property owner would agree with your assessment that all we're talking about here is just square footage of property and no impact on their property?
Objection to the extent it calls for this witness to testify what the property owners are going to say or believe.
Mr. Gordon, this is Stadler. Do you want to respond to the objection?
Yeah, let me withdraw that and ask a different question. In your experience as an appraiser in this area, is it safe to say that it's common that property owners do not look at easements in this limited way?
Objection vague to what property owners believe. And
this is Stadler. I think you could ask the question a little more specifically if you want to try one more rephrasing.
All right, let me try one more time. Mr. Lefevre, in your experience in dealing with property owners who are having these easements acquired, is it common for them to expect more compensation and to have the impact on their property, including existing structures and things, taken into account when establishing a value?
Same objection. I mean, I don't think Mr. Lefevre can testify what the property owner's expectations are.
I'm asking what his what his general experience has been.
On what the property owner's expectations are?
Yes.
This is Brad LeVar, and I think I'm just going to clarify that I'm hearing the question as asking him what his experience with what property owners have communicated to him on this issue. Is it fair to phrase the question that way, Mr. Gordon?
Yes, yeah.
Why don't we put the question to him that way, Mr. Lefevre?
Perfect. Yeah, you know what I find generally with property owners is a lot of variability, as you can guess. Most of the time, I find myself explaining to them the procedures for eminent domain valuation, how easement values are calculated. For the most part, the property owners I deal with have never been through a situation where part of their land is being acquired for, be it power lines, road widening, whatever, and they don't really understand the process. I end up spending a lot of time walking them through it.
Okay. Let's move forward. I think we're where we need to be. Regardless of what your experience has been, in this situation, you did not do that type of detailed analysis on each of the impacted properties, correct?
Correct.
You were told not to do that type of detailed analysis, correct?
Correct.
And in doing your analysis, you did not actually visit the impacted properties, correct?
Correct.
You primarily used Google Earth or some other form of program to make measurements, correct?
I don't believe we made any measurements. Those were provided by project managers for their estimates of how much square footage was going to go into those easements. Appraisers don't typically estimate the size of the easements.
Okay, and let me clarify that. So you received the width of the easements that you were to do an appraisal on from Rocky Mountain Power, correct?
Yes.
Okay. Now, but let me go back. You primarily did use Google Earth to look at the pathway of these easements, correct?
Correct.
Okay. And so there could be aspects of each one of these impacted properties that you do not have information on, which could alter the value of the underlying easement, correct?
Correct. I guess there could always be possibilities there, sure, yeah. I would expect to find it within the range that we've discussed.
Okay. And isn't it true that that's why you gave such a large range of value on each property, from 25% to 75%, correct?
Correct.
Because there's a lot of unknowns based on that your appraisal relies on, correct?
Correct.
Let's see here. Now, as you went through, none of the properties included in your report have transmission lines on them or are going to have transmission lines on them, correct?
I believe that they're all going to have those easements. That's my understanding. What do you mean by transmission lines on? Like the lines themselves going over the property, over the homes? What do you mean there?
As I looked at your report, the 26 that you referred to, none of them have transmission lines on them, and they're not in the pathway of this line, correct?
Oh, my apologies. I thought you meant the properties that were included in the appraisal there. That is my understanding, correct.
Okay. Let's see here. Okay, on page 12 of your report, you cite two historic studies that show transmission line impacts on real property and that they only impact the value 10% or less, correct?
Correct.
And the study you cite was not included in your report, correct?
Correct.
And the study, based on your testimony, analyzed properties solely in Salt Lake County, correct?
That specific study, yes. As far as historic studies, there's been many, but yeah, that study that's discussed there with the 350,000 properties.
Okay. And Salt Lake County is a highly urbanized area and in fact is the most dense county in the state, correct?
I would guess most dense, not certain. Urbanized parts.
Okay. In your professional opinion, would you use comps or comparables in Salt Lake Valley to establish the value of homes or land in Heber?
No.
Why wouldn't you?
I always try to get as close as possible to the area you're appraising with land sales that you're looking at as comparables.
Okay. So why would a study in Salt Lake County be relevant to a transmission line in Midway?
Whenever you're looking at comps, be they sales comps or, and I mean comparables there, be they sales comparables or comparables for something like easement value or impact from a power line, let's say. Ideally, you're looking for those comparables or those studies as close to the property as possible. However, in many cases, especially in a smaller town area like Midway or Heber, you don't have access to something like transmission line studies. They haven't been completed. So you're forced to look at percentage differences from other locations. It's fairly common practice. Some of the transmission studies that are looked at have been all over the nation in some cases. They're looked at to analyze those impacts.
And wouldn't that suggest then that you acknowledge the report that you're relying on is not a perfect fit to the situation of Midway, correct?
Not a perfect fit, no.
And that it draws into question the applicability of that study to Midway, correct?
Applicability, I think that's a relative term. If you're going to look for studies and you're going to have to rely upon a study in something like an appraisal, given that there are no studies that I'm aware of within Heber or Midway, one is forced to look at studies from outside of that area.
Okay, is that the only way that you can establish the value is through studies, or are there other ways that could have been used, i.e. specific appraisals on these properties that was not done?
As you noted, specific appraisals don't really establish the value, just the estimates of value. There's a lot of different ways we come up with estimates of what those impacts might be. Studies is one, attempting to look at properties on a paired sales analysis, very similar properties where there's just that one or two things that are different depending on whatever you're trying to adjust for. Okay.
You state that general market values do not support a value impact between 46 kV lines and 138 kV lines due to the, quote, relatively modest increase in pole height / cross arm width, correct?
Correct.
And that's from that study down in Salt Lake, correct?
Correct.
And do you know if that study analyzed a single circuit 138 kV line?
I do not know, no.
Okay.
Not off my head.
Did you take into account that what we're talking about is a double circuit 138 kV line, which increases the pole size and height over the existing 46 kV line, in some instances by 30 to 40 feet and 8 to 10 times the size and diameter?
I did not specifically account for that, no.
Okay. Did you do any analysis on what size the existing poles are on the impacted properties and what size they will be once the transmission line is upgraded?
No.
Okay. So the report you rely on to establish value impact is based on assumptions from Salt Lake County that you really didn't analyze, correct?
I'd say incorrect. Again, back to what I previously noted, when you're doing an appraisal of any type, an appraiser is tasked with estimating that value. If there's not a study available in the specific market area, an appraiser can't simply say, I'm sorry, there was no study available, we can't give a number. You'll look for the best information available and try to utilize it in the best manner available.
Okay. Do you have any studies that look at the impact on rural property values when pole sizes are increased in both height and size dramatically?
I've not seen studies that get that specific, no.
Okay. In your mind, what is a relatively modest increase to pole height / cross arm width?
Again, I've not seen studies or data that would allow me to be that specific. That's probably a better question for engineers.
Okay, but your study states specifically that you relied on that the whole basis of this is that there isn't a significant or relatively modest, that there's only a relatively modest increase. And so if that's not correct, then the study you're relying on really wouldn't be applicable, correct?
The study looked at 138 kV and 46 kV lines. Obviously, as you've noted, there can be differences in the heights, the layouts of those lines, how the actual power lines themselves are attached, span widths, all of those things. The level of specificity in this or any other study that I've seen would not allow us to say, here's a specific difference where this is 2 feet taller or 2 feet shorter or anything along those lines.
Okay, so let me ask a specific question here to give us a context. I want to consider the property that's located at the intersection of Springtown Road and Cascade Parkway, which is the Johnson property. This property will have a corner pole placed on it that is approximately 90 feet high and 8 feet in diameter, and it will be replacing a pole that's approximately 2 feet in diameter and 50 feet tall. In your opinion, is that a relatively modest increase in pole height and crossarm width?
Well, I'm sure, as everybody knows, that sounds like a pretty good size increase.
Thank you. And you didn't take that into account when establishing your values, correct?
As we've discussed, we didn't establish any specific values for specific properties. We looked at ranges of that land only.
Okay. And in your professional opinion, now knowing the size of that pole, how much do you think that would affect the value of that home, and how much would it be decreased due to the existence of that corner pole?
Oh, I'd have to spend a lot more work than just this moment right here to come up with a value. We spend a fair amount of time in the appraisals.
Okay, but do you agree that it would diminish the value of that home?
I've not done that appraisal. I can't opine to value on an appraisal I haven't done.
Okay, so once again, you really can't testify to what the actual costs or actual values of these easements are, correct?
Not on a property-to-property specific basis, no.
Okay. Now, in your analysis, you determined that none of the impacted properties would qualify for severance damages, correct?
Yes, on a macro scale, that's our opinion.
Okay. What legal research did you do to arrive at the conclusion that severance damages are inapplicable?
Oh, none. As an appraiser, I consider severance damages to be the difference between what the market value of the larger parcel in the after condition, after accounting for the take, less the actual concluded market value in the after condition would be. That, from appraisal terminology, it's a mathematical question based on the appraisal.
I see. So when you're saying in the legal world, severance damages has a specific meaning, your testimony is you didn't look at what the actual legal meaning of severance damages is, and so you can't opine as to whether legally these properties would be entitled to severance damages, correct?
Oh, I would never offer a legal opinion, correct?
Okay. So based on your testimony to the board, the easement costs could range anywhere from $382,500 all the way up to $1,556,250, correct?
Where are those numbers coming from?
I believe I pulled those from your analysis of the per acre in your report, and then just extrapolated those that we take 25% of the total and then all the way up to 75% of the total.
I don't believe that we know a measurement of each individual easement on each individual property. I do not believe that was in my report anywhere. We've concluded those values, those ranges of values, just on a price per acre basis. Looking at each of those individually and trying to apply the square footage on each of them, I don't believe that's information that we looked at.
So what have you given to the board then? There's no range of value that you feel comfortable recommending to the board?
Our scope of work in this assignment was to look at likely ranges of land values, to estimate easement impacts to those land values, again, those percentages of fee, so that could be used as an estimate by the client in determining what those likely costs would be for acquiring the easement.
Okay, so your analysis really cannot be used by this board to determine what the actual costs of these easements are, correct?
I don't believe we're looking at, I don't believe I was given specific sizes for specific properties, and again, we haven't concluded any specific properties, so no, this would not be the final number by any means.
Okay, very good. Last question. Rocky Mountain Power has provided Midway City with an estimate that the easements would only cost approximately $27,000 total. In your opinion, that estimate is dramatically low, correct?
I can't have an opinion on an estimate someone else provided. I've not given that number myself and can't opine to it.
Well, but so are you saying that you can't even give what you think the minimum value of these easements would be?
I can say that I believe those easements would fall between 25 and 75% of fee value, depending on the specific impact to specific properties.
That's all I need to know. Thank you. No further questions.
This is Thad LeVar. Thank you, Mr. Gordon. Mr. Morris, do you have any questions for Mr. Lefevre?
I do, thank you. Mr. Lefevre, you mentioned you had done work for Rocky Mountain Power and also you may have dated yourself. I don't know if you said Mountain Fuel or
yeah, I think I said Questar, didn't I? Oh my goodness.
Well, that would date you as oil, at least based on the last gas bill I got.
It's kind of like the way I still call it the Delta Center, right? It's always going to be the Delta Center.
Well, I'm with you there too. By the way, my name is Mark Morris. I represent a group of citizens that formed an entity, and it goes by the acronym of VOLT. Have you heard of that before?
Yes, just during some of the information I've received as part of these proceedings.
Okay. So back to my original question, you mentioned you've done some work for Rocky Mountain Power and also now Dominion. What percentage of work that you do is for utilities versus homeowners?
I'm going to object to the question. I don't think he said he's done work for Rocky Mountain Power and Dominion. I think he said he had interviewed or talked to representatives from those companies about acquiring these type of easements. So I just wanted to clarify that.
If I got it wrong, please clarify for me, Mr. Lefevre.
Sorry. So what's your question? Whether I've done work for those entities?
Have you done work for Rocky Mountain Power before?
Yes.
Have you done work for Dominion and its predecessor entities?
You know, I don't think I have. I know some of the other appraisers in our office have.
So your firm has done work for Rocky Mountain, right?
Yes.
And your firm has done work for gas utilities?
Yes.
And my question is, what percentage of the work that your firm does is for, I'll just characterize them as institutional clients like utilities versus homeowners?
You know, good question. I don't know if I know a percentage off the top of my head. I do know we don't discriminate between the let's say large condemning authorities versus homeowners. If I get a call for an appraisal, I'm happy to do it. I've done a lot of work for both condemning authorities and homeowners or property owners.
Okay. during the course of your testimony, when Mr. Gordon was asking you questions, you indicated, and I don't want to get repetitive here, but generally you indicated that you had a scope that you were given, right? Rocky Mountain Power gave you a scope of work for you to do.
Correct.
Okay, and you part of that scope was, well, you know, I think this ground may have been plowed.
I love that saying, by the way.
Well, an appraiser should like that. So we know that you were not asked to come up with any severance damages or opine whether any would be coming. You know, I was intrigued, though, Ron, you were testifying about, you know, what easements are worth, but you did not go on to discuss, you know, impact on the after remaining property. Was that earlier testimony another way of describing severance? I just want to make sure you were talking about the same thing, or if it's two different things.
Yes, in appraisal terminology, damages, you know, and including severance damages, are analyzed based on that value of the remainder in the after condition after the acquisition, whatever that might be. Let's say a property acquisition on a partial road widening or an easement, whatever that might be.
Okay. And you indicated in your testimony that you had minimal involvement in the report. What does that mean in hours? And before you signed your name to the report, how many hours did you put into it?
I'm probably in the range of about 10 hours. Most of the work was done by Eric Leinhart and Troy Lunt.
And do you know how many hours they put in?
I do not. I know it was substantial. I remember Eric talking about spending quite a bit of time on it, and Troy as well. I didn't see how many specific hours they had.
Okay. You also characterized the report. I'm just looking at the first page of your testimony where it was from a cursory study. You see that? I'm looking at the first page of your testimony. It's line 28, 27 and 28. You say, we have concluded a range of value based on a cursory study of land sales and listings in the area. What did you mean by cursory?
I think that, you know, and what's the best descriptive word? Hey, everybody's always guessing at that. As we've well noted here, we looked only at land values in the area. We concluded ranges of value. We did not look at specific properties, specific impacts. So, you know, is cursory the right word for that? Yeah, I thought so.
Okay.
I think that the description we've given is probably a better description, even with more detail.
I'll accept your characterization of what you performed. Now, for purposes of your work, you did make an assumption about the width of the existing easements for the existing line. Is that right?
We had that based on the information provided by Rocky Mountain Power and their estimates of how much would need to be acquired. So not an estimate that I made, but again, a good question for engineers there. So we utilized that figure.
And so I'm looking at the second page of your direct testimony on line 5, lines 4 and 5. You say, quote, it is understood that the additional area needed would be 1.5 feet from center line, which is just an increase from 27 feet from center line to 28.5 feet from center line. You see that language?
I do, yes. And you know what? You've pointed out a spot where I probably should have been a little more specific. 1.5 feet from center line makes it sound like it's only coming off 1.5 feet. The intent there is to say an increase of 1.5 feet, as we've clarified following from 27 feet to 28.5, for instance, or that additional under the other option of 2 feet from 27 to 29.
And that's how I took it. But my question for you is, who told you it was 27 feet on either side of the center line of the existing line?
We were given that from Rocky Mountain Power on their estimates of what needed to be acquired.
But just to be clear, you weren't told 27 feet would needed to be acquired. You were told 1.5 feet would need to be acquired, right?
Yes.
Okay.
An additional 1.5 feet, yes.
Right. And you don't know who on your team got that number from Rocky Mountain?
I don't know exactly the name of who that came from. I know Ben Clegg was involved in some of that information. That was the number. I'd have to go back through and look at notes to see exactly who said it.
Okay. Now, if I were to show you a bunch of pictures of the existing line, that's not something you'd be familiar with, correct?
I have seen pictures of the existing line. Possibly.
Okay, so you haven't visited the line personally, but you have been shown pictures of the existing line?
Yes, I have not visited personally.
Did those pictures reveal to you that people were maintaining a 54-foot wide easement on either around the existing line?
From an appraiser standpoint, I don't get into the questions of who might be maintaining which easements. I can't think of an assignment that we've had that I've had as an appraiser where I've been given the task of estimating the easement. That's well outside of my expertise. That's for the attorneys and the engineers.
I understand that, but you know approximately what 27 feet linear feet looks like, correct?
Mm-hmm. Correct.
I revert to football fields. I mean, it's almost 10 yards.
Sure. We all know what 10 yards looks like. Absolutely.
So it's just a yard short of 10 yards. But you aren't in a position to tell us whether the photographic evidence you looked at the line supported or contradicted anyone's claim that there was a 27-foot from center line easement running along the existing line. Is that right?
Yeah, I'd say I'm not in a position to say anything about the easement based on that. I of course see a lot of easements, and many of them look very different. I think what you're asking is does it look like there was a cleared path around it in that basis? And those easements, I can't comment as to the easement really. It's not something I would have been looking for or would even look to comment about.
Let me just bring up the parcel of Mr. Johnson that Mr. Gordon asked you about. That's going to have I think you conceded it was going to be more than a modest increase in the size of the pole in his yard. Do you recall that testimony?
Yeah. It sounds like bigger numbers there, definitely.
If Mr. Johnson had hired you to assess what Rocky Mountain should pay him for an easement going through his yard, what process would you undertake?
So for any easement acquisition, property acquisition, the process is fairly consistent. Initially, we identify the larger parcel. Quite often, it's the parcel owned by the property owner. Then we look at the value in the before condition of that property. We would then estimate the value of the part to be acquired, whether that be a actual acquisition of land, whether it be an acquisition of an easement, whatever that might be. And then we would look at the value in the after condition of the remainder to assess differences there for damages.
Okay. So it sounds to me like there are two elements. One would be the number of feet that would be required to be added to the easement would be the first calculation. Is that right?
Yes. Yep. I always call that the acquisition, the part or the right that's actually going to be acquired.
Okay. And so whether it's 1.5 feet or 20 feet from the center line, that in additional width that you would need, that's how you refer to that, the acquisition?
Yes. Mm-hmm.
And then to arrive at a dollar figure, what do you do with the number of square feet that math brings to you?
Yeah, we'd use that value in the value of the land in the before condition and apply that valuation to the number of square feet. You know, if it's a full acquisition of property, that would just be done on a fee basis. If it's an easement, we determine what portion of fee would be the applicable amount to deduct there as a portion of fee value for the easement.
Okay. And for diminution of value, severance damages or after impact, however you've referred to it here, what would the process you would undertake for that be?
So we then look at the property in the after condition, you know, with those improvements, the new acquisition, whatever the project is, with that project done and in place, and we would estimate the value of the property in that after condition. And then the difference between what the value in the before condition, less the part acquired, and the value in the after condition would be calculated as damages.
Okay.
If there's a negative difference, obviously, if there's a positive, that would be calculated as a special benefit. I'm sure everybody's familiar with those terms.
And you would agree with me that there is at least the potential for someone's property to lose value, even if it's not directly underneath these lines with the change that comes?
Potential, yes.
Okay. Let's see. Mr. Gordon did a pretty good job of gutting a lot of my questions here, so I'm going through this. I'm crossing out the things we've already covered.
You always want to go first, Mr. Morris. That way you don't have to change your plan.
Well, I'm going to have a chat with Mr. LeVar about that. Let's see. There was a line that caught my eye in your testimony that you indicated that overhead lines won't impact the, quote, functional utility, end quote, of parcels in its path. Do you recall that opinion?
Yes.
I just want to make sure I understand what you're saying there, that overhead lines, when you say functional utility, I assume if it's a home, I mean, people can still pull up in their car, go and watch TV, eat dinner, go to bed, and the home can still function as a home, right?
Yes, and we were looking at specifically land, and so the conclusion there in our report is based again on land and land value ranges. But you've got the right idea there. The land would still remain, in all likelihood, generally for a power line or something across the frontage, the land still remains functional for all of those uses that it could have been put to before.
But a change in function, but the absence of a change in functional utility does not translate into no change in value. Is that correct?
Correct.
Okay. Have you read Ron Lowry's direct testimony that he submitted in this proceeding?
Ron Lowry. Yes, one of the two property owners, the Bolt members. Is that correct?
Yes. did you read his account of having to reduce the sales price of his home because the buyer was concerned about these overhead lines coming in?
Yes, I recall him saying that he had a price that they were wanting to ask, and they reduced that in order to sell it. Is that correct?
Yes. That wasn't surprising to you, was it, as an appraiser, that a buyer of a home would offer less because of the threat of overhead lines coming in to the area?
Yeah, it's sure, yeah. A lot of reasons buyers offer less. His opinion appeared to be that was the reason. Yeah, definitely there are people that would offer less, and I think buyers offer less for a variety of reasons.
On the occasions, Mr. Lefevre, when you have given an opinion to, let's say, a condemning authority like a power company or a gas line, and the homeowner challenges your conclusion, has there ever been an occasion when your estimate resulted in, or that the conclusion, whether it was by an agreement and a settlement that was reached, or a judge or a jury decided, if the condemnation case went all the way through, that your estimate was woefully low?
I'm going to object to the basis of this questioning. What's the relevance of this on this proceeding? It seems like it's repetitive, and we're just dragging this out.
Well, I don't think anyone has asked this question. I'm sorry, Mr. Chairman LeVar.
Well, no, I was just going to go to you, Mr. Morris. Go ahead.
I don't think anyone's asked that question yet, so I don't think it's repetitive.
And my first objection was that it's not relevant to this proceeding.
Okay. And as to relevance, Mr. Chairman, Rocky Mountain has suggested that the standard cost for the overhead lines it's proposing includes an easement valuation of $27,000 approximate dollars. Our contention is that is woefully low, and since they have put on Mr. Lefevre to apparently support that contention and say the impact is relatively small, I think I'm entitled to cross-examine him on that issue.
Mr. Lefevre has not testified that the amount's $27,000, so I think that's where I don't understand the question for this witness.
Okay, this is Sam. I think at this point I'm going to overrule the objection and kind of see where this goes. I'm going to give a little latitude to especially considering the objections to the witness. I think it's appropriate to give some space to develop this a little bit further.
Thank you, Mr. Chairman. Do you remember my question?
I do, yeah. The word woefully, it's obviously a big word there.
I'm sorry. That might have been pejorative. Let's go on percentages. In your experience, given a number that you have initially come up with for a condemnation proceeding on behalf of a condemning authority, what's the most drastic end result in terms of a percentage increase over your original number that either a settlement or a judicial determination has resulted in?
I couldn't give a specific number without really going back and looking. I can tell you that there have been plenty of times in my career where I was the high of the appraisers and plenty of times where I was the low of the appraisers. Definitely there's going to be some differing opinions amongst appraisers.
Well, and of course, among appraisers, that's going to be true. But in terms of the ultimate result, not a difference of opinion, but the hard fact at the end of the process that the condemning authority has to write a check for an amount that is some percentage greater than the one you originally thought they would have to write. Does that clarify my question?
Yes, thank you for that clarification. Yeah, my answer would be almost the same. There have been many times where it turns out I was below where it ended up, and many times where it turns out I was above where it ended up.
Again, Mr. Gordon has stolen a lot of my thunder here. I'm just trying to avoid plowing old ground again. Give me a minute.
Of course.
Did anyone at Rocky Mountain tell you why they didn't want you to speak with anyone real property owners here?
The discussion that we had with Rocky Mountain was that they were trying to come up with some estimates of what it was going to cost them to acquire right-of-way, and needed a reasonable idea of some rough value ranges for that.
Okay, let me have you turn to an exhibit. It's vault number 7. I could get Mr. Reich to show that to you.
Looks like they're looking for a book right now to pass over to me.
For 2. What's that one?
Which exhibit did he say?
Number 7, is that correct, Mr. Morris?
Yeah, vault 7.
Yes. Got it here.
This is from your report, actually. It's from your direct testimony. Do you recognize this summary?
Yes.
This identifies 12 impacted properties that were evaluated in some fashion, but can you tell us, why did you identify these 12 properties as being impacted?
These were the 12 that Rocky Mountain said would be impacted by the increase in the easement width, as my memory serves.
I see. So this isn't really your conclusion. This is Rocky Mountain's conclusion.
No, yeah, as I've mentioned, as an appraiser, we don't generally, well, never that I can think of, have I made those estimates as to which properties would be impacted by an easement, things like that. That's something that a client comes to us and says, here's the easement that we want to put through, and we need some value estimates.
That answers my question on that. I don't think I have any other questions for you, Mr. Lefevre. Thank you very much for your time.
Hey, thank you.
Sad LeVar, thank you, Mr. Morris. I think we'll go ahead and take a 10-minute break before we go back to any redirect from Mr. Reich. So we'll recess for 10 minutes. I will make, before we go, to Mr. Gordon, you had indicated that you might only want to call one witness this afternoon, so I'm going to request that you be prepared to call more than one, depending on how much progress we make. I would hate to get an hour or so down the line and have to stop early because we don't have witnesses available. So let's make sure we're prepared to go forward in case the opportunity presents itself.
That's not a problem. We'll prepare our witnesses.
Okay. Why don't we recess for 10 minutes, and then we will go to Mr. Reich's, if he has any redirect for Mr. Lefevre. Thank you. Mr. Reich to see if you have any redirect questions for Mr. Lefevre.
I do. Mr. Lefevre, you were asked in the cross-examination about functional utility. Let me refer you to your direct testimony on page 4, looks like line 25, where you state that the sentence is, this is primarily due to the fact that the functional utility of the parcel is not materially impacted. Could you elaborate on what you mean by that?
Yes, many aspects of value, obviously. One of the things that we look at quite often is what the potential use and potential utility of a property is. That's what I mean by functional utility. If that is unchanged, that's going to be one of the indicators that we would look at to see if there's likely going to be a change in value.
Okay, thank you. And then I also had I know you were given several hypotheticals, and I just wanted to change the hypothetical slightly and ask you this question. If you have a property where there's no physical taking, for example, if the property does not touch the easement, are you aware of any circumstances based on your experience as a certified real estate appraiser that would allow the property to receive severance damages?
I'm not, no.
No more questions.
Thank you, Mr. Wright. Mr. Gordon, do you have any follow-up questions for Mr. Lefevre based on that redirect?
I do not.
Mr. Morris?
I just have a couple. Again, if you haven't left that page 4 of your testimony, lines 24 and 25, you say the market does not generally recognize a decrease in land value of the larger parcel due to a similar utility easement along the property perimeter. Do you see that?
I do, yes.
Did someone from Rocky Mountain tell you that the easement was going to be similar if the overhead line that is planned here is installed, in fact?
No.
Okay. And then the second question you were asked about whether someone who doesn't have property actually on the line being entitled to severance damages. You're not an attorney, are you?
I am not, no.
And so it would be a legal question as to whether someone were entitled to severance damages who had a property that wasn't immediately on the utility line, wouldn't it?
I'm going to object to that question. The question that I ask is if he's aware of any circumstances as an appraiser. It wasn't whether or not it was a legal conclusion.
And I'm going to agree with the characterization of Mr. Wright's question. That's how I remember it as well. Mr. Morris, do you want to rephrase your question or rephrase your characterization of the earlier question?
Yeah, let me, I appreciate the clarification. I remembered it differently, but if the question was, Mr. Lefevre, you're just, in your experience as an appraiser, you don't have any experience or any history or knowledge of someone who had property near a line but not on it, getting severance damages. That's your testimony? You're not aware of someone?
I would clarify that I'm not aware of anyone getting damages or severance damages where there wasn't an acquisition to their property.
I see. Okay. And so if someone who was next to the line but didn't have an acquisition but was very close to the line, were to hire you as an appraiser and say, I think I've suffered severance damages because of the easement expanding and these poles coming in and ruining the aesthetic of my neighborhood, for example, or because of a fear of greater electromagnetic, radiation coming from the lines or something like that, would you tell that person they're out of luck, you really can't help them?
I actually have in many cases, yes. I get it more often with road widenings. Someone will call and say that, the road behind us is getting widened. We're going to be damaged. I've told a lot of property owners that they should get a legal opinion, that it's my understanding they wouldn't be entitled to any compensation, but again, that they should get a legal opinion.
And if they get a legal opinion, you're happy to go and assess the impact on value?
Yeah, as an appraiser, I estimate value, and if if there's a legal opinion that somebody thinks that's the case, I'm happy to give a value estimate. But like I said, I've had a number of those calls, and I usually point them to go look for a legal opinion because I tell them I don't think I can help them.
So in your experience, there actually could be a diminution in value. You just don't know if they're entitled to be paid anything for that diminution.
Oh yeah, there's a lot of things that can cause changes in value. And yeah, that's exactly the advice I give people is before hiring an appraiser and paying a bunch of money, they may want to make sure that that's actually something they could get.
I understand. Thank you very much.
Thank you.
Okay, thank you, Mr. Morris. This is Thad LeVar. Do any board members have any questions for Mr. Lefevre? I'm not hearing any questions from board members, and I don't have any. So thank you for your testimony today, Mr. Lefevre.
Thank you all.
Mr. Reich, anything else from you at this point?
No.
Okay, we will go then to Midway City. Mr. Gordon or Mr. Jukes, you can call your first witness.
Yes, this is Mr. Jukes. We are going to call Mr. John Nelson as our first witness. Now, we were a little unsure of the exact time he would be called. Let me ask if he's there on the line. We asked him to call in. John, are you there?
Yes, I am.
There we go.
Are you able to hear me?
Yes, we can hear you.
Okay, good.
Okay, thank you. Mr. Nelson, this is Thad LeVar. I'm conducting the hearing. Do you swear to tell the truth?
Yes, I do.
Okay, thank you. Mr. Gordon?
So this is Mr. Jukes that'll be conducting the examination for the record. And I'm sort of 0 for 10 today with all my objections, so I'm hoping I can redeem myself a little bit. Feels like we need a little levity here, right? Mr. Nelson, appreciate you being here. Where are you physically located?
I'm located in Evergreen, Colorado.
So currently you're not in our office. You're just calling in over the phone from your office in Colorado.
That is correct.
Have you listened to any of the testimony that's been presented during this
Just about
hearing?
the last 3 to 4 minutes. I called in and I listened for about 3 or 4 minutes.
Now, have you had an opportunity to review the written direct testimony that's been submitted to this board in your name?
Yes, I have.
And is that true and correct, and say what you wanted to say?
Yes, it is.
We move that it just be submitted to the board as Mr. Nelson's direct testimony.
This is Thad LeVar. If any party objects to that motion, please indicate your objection. I'm not hearing any objection, and the motion is granted.
Now, I don't want to spend much time on that written direct testimony. I got to tell you, throughout this hearing, I've had some trouble keeping up with all the technical words. So I just wanted to ask you, Mr. Nelson, for some simple explanations of some of the terms we're talking about. And I know that you prepared just a couple of slides. If you wouldn't mind pulling those up. And for the board, these are the just demonstrative exhibits that we sent around. They are not offered as evidence. It will just be used in an explanation of some of the concepts that Mr. Nelson's speaking of.
I've got those in front of me.
So I just asked for permission, if this were a trial, I'd ask for permission to publish it to the jury, but I'm asking for permission to publish it to the board members, I suppose, and if there's any objection.
Sure, this is Thad LeVar. Do any board members having any trouble getting these images in front of you? Do you all have them? If you're having trouble, indicate it. If I don't hear anything, I'll assume we all have it. Okay, sounds like it's in front of all of us. Go ahead, Mr. Jukes.
So if you turn to the second one of those slides, it's an overhead to underground transition. There's been a lot of talk about certain types of poles and cables. What is this a picture of?
This is a photograph that I took off of Google, and it's not a representative of what you'd see in the Midway project. However, the voltages might be a little bit higher there. But what I was trying to show primarily to you, Joseph, and to Corbin, was what an overhead to an underground termination structure might look like. So as you see on this structure, you've got on the cross arms that are about, halfway up the pole or 3/4 of the way of the pole, you have three-phase conductors coming in, and then they're dropping down to termination fixtures and lightning arresters. And then that's our transition from overhead to underground. And on the lower cross arm, the dark figures are the terminations, and the thinner fixtures off to the side of the outer ones are the lightning arresters. So that's just a rough indication of what it takes to go from overhead to underground, as would be the case in Midway.
And based on your experience, is it something similar to this that would have to exist in Midway should this be brought underground?
So, something very similar to that.
Now, if you look at the next picture, it looks like you've got something comparing cables. Can you tell us what this is?
Right. What I was wanting to show here was that we were looking at an overhead power line that's coming in from Georgetown to the Midway substation. And for everybody's information, the type of conductor that we'd be looking at is that depicted on the right. And in this case, I was trying to represent a 795 ACSR conductor, which the ACSR is aluminum conductor with steel reinforcement. If you look at that conductor, you'll see in the center a little darker braids, and that's the steel reinforcement, and the aluminum is on the outside of that. What I was trying to show is the difference between what an overhead conductor looks like compared to that of an underground conductor. Where the overhead conductor is using air as a dielectric or the insulation, it's a very good insulator. When we place a conductor in a duct or direct buried, we have to actually put a solid dielectric covering around it. The conductor that we're looking at in this particular case is a 1250 MCM, which is 1250,000 circular mils, and it's copper instead of aluminum. The copper has better conductivity. That's what you're seeing in the center of that conductor. And we're able to use actually a smaller copper conductor because the conductivity versus that of an aluminum conductor. On the outside of that, you'll see a shield around the copper conductor, and then the white portion in this particular case is what we call cross-linked polyethylene insulation. It's XLPE, which is the abbreviation for that. And that's a very good dielectric, especially for high voltage power lines like this or power cables like this. There's another insulator in the industry, which is EPR, which is ethylene propylene rubber. And there's always a controversy from one manufacturer to another, which is better, but they're very good insulators for the underground cable. Then on the outside of that, we're going to have a what we call a semi-con layer. And then if you see that metal that's going around it, it's a combination of a shield. And I believe in the case with Rocky Mountain Power, they're using an aluminum sheath around it, which is pretty much impervious to moisture. It keeps the moisture out of the conductor. And then the black on the outside is the final jacket that can be used, for the conductor.
Well, let me stop you there and suggest that we not go into so much detail. I think the main thing that we want to illustrate here, that's fine. Certainly you know your stuff, but there's a difference between the overhead cables and the underground cables. Is that right?
Exactly.
And when you say conductor, that's the actual energized cable, is that right?
That is correct.
So going to the next page, just very briefly, this is, can you tell us what this is?
What I was representing here on the left is a double circuit single trench where two circuits, such as, the Heber Light and Power and the Rocky Mountain Power circuits, could be placed in one trench. The benefit of this is a single trench versus what's being specified here is a double circuit with two separate trenches and with material in between the two.
And the duct work is the bottom part with the circles in it?
Yes, the ducts in the large circles that you're seeing here are basically 6-inch plastic conduits. And each one of those conduits is a duct.
Turning to the next page, it looks like it's a construction of one of these ducts, is that right?
What we're looking at on the next page is that these ducts will be going from the termination pole to some point that we need to make either a splice or use it for pulling the cable. So these are actually underground vaults, and this is typically what you would see in an application like the one in Midway.
Where would you see this, would you suspect in Midway, should this be built?
There's going to be, depending on the length of the cable pole, these will be along the route. The first one, if we start at the east end of the option A, which starts at South Center Street, there would most likely be one in that location to allow the transition from the underground cable going up to the terminating structure. Then approximately anywhere from maybe 1,200 to 2,000 feet, there would be another one where the cable could be pulled in. And because you can only get a certain amount of length on a reel, a splice would have to be made, and that'd be a good location for the splice. So it'd be along the roads between the two locations.
But turning to the next page, is that a splice that would exist inside one of these vaults?
Yes, I was trying to represent what it would look like inside of a vault, and one of the purposes for the vault would be to have a splice like this. Yes, that's correct.
Let me ask you this, Mr. Nelson. At a very high level, can you just tell us what you believe a reasonable estimate of the actual cost of this line is going to be?
From a very high level, I'm going to have to go into a little bit of description here because I was provided the bids that were solicited by Rocky Mountain Power, identified as bidders 13, 15, and 17. And what I did at that particular time is I did just kind of a quick cost comparison, just looking at their items in the bids. And I didn't feel comfortable with that because I do a lot of engineering cost estimates, and I used a different spreadsheet, and I came up with a number of roughly $8.1 million per mile using the Rocky Mountain Power specifications.
Is it your testimony that even those specifications are too conservative?
I believe the specifications are quite conservative, and we could actually look at a less conservative specifications. Yes.
Would less conservative specifications be permitted by industry standards?
Yes, they would. In fact, I did what I would consider a reduced specification cost estimate for the same distance. I mentioned $8.1 million per mile for the Rocky Mountain specifications, which calls for 4 conductors per circuit instead of 3. And I did a less conservative specification cost estimate with 3 conductors and came in about $6.3 million.
Do you know why Rocky Mountain Power has included these issues that you consider to be conservative in their specifications?
Objection,
Yes.
calls for speculation. Can't testify why Rocky Mountain Power included things in their specifications. calls for speculation, no lack of foundation.
Okay, Mr. Jukes, do you want to respond to the objection?
Briefly, I believe that based on this person's expertise, having reviewed many, many specifications, he can testify why things exist and for what purpose.
I agree with that, but I don't see how he can testify why Rocky Mountain Power included certain things in their specifications, and I believe that was the question, unless I misunderstood it.
Certainly. So, I mean, I think I'm going to allow the question to go forward on this basis, that if the witness could answer why specifications like those included by Rocky Mountain Power would be included by a utility. Is that Mr. Jukes, is that a fair restatement of your question?
It is. Thank you.
So go ahead and respond.
Yes, Mr. Nelson, if you'd go ahead and respond in that way.
Sure. Utilities have different philosophies, for reliability. And it would appear to me that Rocky Mountain Power felt that the reliability was such that they needed a spare fourth conductor in the duct bank in case anything happened with the cables. It's not a real common practice, but it is practice that could take place and allows Rocky Mountain Power to restore power quicker than if there were only three conductors and a failure were to take place. So it would improve the response time and the downtime for a failed conductor or a failed circuit.
What's the alternative to doing that?
The alternative would be to basically rely on the three conductors rather than four. Now, one of the things we need to realize on a underground circuit like this is that perhaps 90-95% or more of the failures do not occur in the cable. They actually occur on the terminations or the splices. And so with a high degree of probability, if there were a failure or a problem with that cable, it's going to occur on a splice or a terminator where those could be repaired, replaced, within maybe a day or two. There's a time frame that's going to be involved there. With the four conductors, instead of having that additional time, they would have to test the cable either with three conductors or four conductors, determine where the problem is. But with the fourth conductor, they could go up on the terminating structure and just reconnect the fourth conductor to where the third conductor that had failed was located. So it'd be much quicker to restore power with four conductors than with three. But again, the probability of a cable failure is quite remote, but they do happen.
There have been witnesses for Rocky Mountain Power that have testified today, and you weren't present, but I'll represent to you that they said that the reason they need that fourth conductor is because of the lead times involved in getting a new cable. Is there some way to remedy that concern without putting in a fourth conductor now?
I'm not familiar with all of the underground systems that Rocky Mountain Power has, but just taking this one by itself, I would recommend using three conductors and having a spare reel, which is going to be about 1,800 to 2,000 feet of cable, basically in the warehouse in case a cable were to fail. I would also put in inventory anywhere from 2 to 4 splices and 1 to 2 terminations, and be able to repair the cable with that equipment that's on hand. Relying on a manufacturer to furnish this cable is very iffy, because they may not have any in stock. They may have to manufacture it. If they have to manufacture it, it could be a special run, it could be a costly run, and it could delay the repair of the failure.
Let me ask you this a different way. Are there any governing industry standards that require a fourth conductor to be used?
Not that I'm aware of.
Give me just a moment. Let's talk a little bit about the dual trench design. Is it your recollection that the Rocky Mountain specs call for this?
Yes, the Rocky Mountain specs called for this, and both my cost estimates involved dual trenches, or dual duct banks, two separate duct banks.
How does that impact the cost of this project?
There would be a cost savings by going to a single trench. It'd be easier for the construction, possibly fewer materials such as concrete backfill, the thermally enhanced concrete backfill. It would be less costly to go with a single trench, but since Rocky Mountain Power had two separate trenches in there, that's what my cost estimates were based on.
There was a Mr. Clegg that testified earlier, and he said that the National Electric Safety Code, or certain provisions of it, require two separate trenches or duct banks. What is your opinion on that?
I disagree with that.
Why?
If you look at the National Electrical Safety Code, it basically is a design code for putting in overhead underground lines, substations, and so forth. And there is verbiage in there talking about when you can have, let's say, joint use equipment and when you can't have it. I've found no area that prevents you from having a joint duct bank. The only caveat I would say there is that the utilities that are putting in, let's say, a common duct bank would have to be in agreement to doing so. To give you an example of what we've done on the Rocky Mountain cost estimate and the design, I have considered two separate duct banks, one for Heber Light Power and one for Rocky Mountain Power. And rather than having a common manhole or vault, I've installed separate vaults. That way, the cables, where they are exposed to a worker, Rocky Mountain Power would have theirs, Heber Light Power would have theirs. If we wanted to, and if both Heber Light Power and Rocky Mountain Power agreed to it, they could put it into a common trench. And then when they get to the manholes, they could actually expand the conduits out into the separate manholes. But this would have to be an agreement between Rocky Mountain Power and Heber Light Power. It could be done. I feel it's within the compliance of the code. But if one or the other or both do not want it, that's why I stayed with the two individual duct banks.
Well, it sounds to me like your estimate also includes two separate duct banks. What specs did you alter from the Rocky Mountain specs to lower your estimate?
The primary cost savings was within the 3 and the 4 conductors, because you're reducing, the amount of cable, the number of splices, the terminations, the labor, and so forth. My lower cost estimate still had the 4th conduit, such that if a cable were to fail, and rather than pull out a cable, all you'd have to do is install the 4th cable as a replacement cable. But again, recall that that's a very low probability issue. If there's a problem in this underground power system, cable system, like I said, well over 90% of the probability is it's going to be in one of the splices, which is going to be in the manhole, or one of the terminators up on the termination structures. So it's very unlikely that you're going to have to repull the cable. Hello, are you still there?
Yeah, sorry, I had it on mute.
Okay. Okay, that's real quiet.
Is there a safety or reliability reason for needing dual trenches or requiring that?
I don't believe there's a safety or reliability issue. It's a coordinated issue. If you look at the present overhead power line, Rocky Mountain Power is sharing a structure with Heber Light and Power. You know, so here's a situation where they're basically using, you know, the same poles for joint use. So
more
from
of a convenience
point
issue?
of view, there's some technical issues that could be brought up that, you know, would favor the dual trenches and the single trench. So I have no objections going with the single trenches or the dual trenches or the single trench. But since Rocky Mountain Power had specified that, I felt that both parties were probably wanting the separate ducts, and that's why I left it like that.
Would you have preferred to have gotten a verified bid rather than a cost estimate?
I always like to have verified bid, but in the short time frame I had, I didn't have time to do that. In fact, I actually did try to get one from a contractor that I've worked with, but that contractor was not licensed in the state of Utah and was not also an acceptable bidder for Rocky Mountain Power at this time.
There was some testimony earlier from Mr. Myers, and I know you weren't here, about some errors in the length calculations by the bidders. 2 of the 3 bidders, that is. Did you also discover these errors when looking at the bids?
Right, I discovered those several days back because when I took the measurements using Google Earth, because we have this coronavirus where I wasn't able to go out to the site, the distances I was measuring were consistently shorter than those that were in the specification. And so, my calculation showed that the actual distance for option A was about 5,400 feet. When I looked at the Rocky Mountain Power specifications, that same option 1 was listed at 6,990 feet. Option 2 involved about another 400 feet to the west of South Center Street, which would take my numbers up to like 5,800 feet, where Rocky Mountain Power's was up to 7,400. And then option 3 went from South Ward's Lane up to the substations, about another 1,700 feet. And all of the numbers were consistently high by about 1,500 to 1,600 feet. So I still did my estimate based on what I saw on Google Earth, and I did compare that with Rocky Mountain Power's and found that they were pretty much consistently 1,400 to 1,600 feet longer than what I anticipated. I should also mention that if I look at bidder 17, which on option 1 was a little over 11.1 million, and if I were to correct that for the distance, a shorter distance, that bid and my bid are very close to the same. Or my cost estimate is very close to the same as bidder 17.
So as a practical matter, how significant are these erroneous distances?
Fairly significant, because when we look at the cost per foot, and I don't have an exact number, so I'm giving an approximation, I think the underground cable came in at somewhere like maybe 1,600 feet. And if we look at that over the 1,600 feet, it amounts to about $2.5 million. And again, those are approximations. I don't have the exact numbers right in front of me. I'd have to go back into my file and check. But it's in the range of, a little over $2 million.
Are there any other projects, recent projects that you worked on that lend credence to your cost estimates in this case?
I've worked on a number over my career, but one of the contractors we use a lot is Interstate Electric. and they did a project up in Teton Village, which was a double circuit 115 kV line. So it's very comparable to this double circuit 138 kV line that we're talking about in Midway. That particular project also included the same size of conductor that would be used at Midway, the 1250 MCM copper conductor. That was a little bit longer project. It was, I think, close to 2.5 miles. Very similar to it, concrete duct bank. They placed everything in the same trench. They did not have separate trenches, so there's a difference there. But that was a project that I looked at fairly recently, and that was a 2017 project.
And did your findings in that project influence your cost estimates in this case?
I actually looked at that, and when I looked at the cost, because Interstate Electric on their website actually has a summary of that project with a number of photographs, and they did that project for $7.2 million, including terminating structures on one end and going into a substation on the other end. And that equated to about $2.8, $2.9 million per mile. So my cost estimate based on the Rocky Mountain Power specifications, were much higher than that.
Well, just so that I understand, your cost estimates for this case that you've given are significantly higher than what was actually used in the Teton Village case?
That is correct. So I feel, and I felt at the time that I put those numbers together, that I did a very conservative cost estimate, which I try to do. I try to come up with a cost estimate that's going to match the installed cost or maybe be, slightly higher. I don't like to underestimate a project. So my numbers, I felt, were relatively conservative.
In your opinion, what is the lowest amount that would have to be paid to complete this underground project in Midway in a safe and reliable manner consistent with industry standards?
I would utilize my less conservative cost estimate, about $6.3 million per mile. I think that would be reasonable, safe, and reliable.
Okay, thank you, Mr. Nelson. I don't have any further questions.
Okay, thank you, Mr. Jukes. Mr. Morris, do you have any questions for Mr. Nelson?
I do not. Thank you.
Okay, thank you. Mr. Reich.
Yeah, I have a few follow-up questions, Mr. Nelson. Hi, this is Brett Reich with Rocky Mountain Power.
Good afternoon, Brett.
Good afternoon. I appreciate you taking the time to be here today. I have a couple follow-up questions about your testimony, and I want to get a little bit of better understanding of your background. Have you ever actually constructed an underground pipeline? Has been a project manager out in the field?
I've worked on underground projects since about 1975. My original project as a protection engineer on 115 kV oil-filled cable for Public Service Company of Colorado. I have done construction observation on underground cables.
Let me just stop you right there. So was that an underground? Are these underground projects that you were actually out in the field on?
Yes, these are all underground. The most recent one I worked on was in, I think it was Corpus Christi, Texas, on a LNG plant where they were installing a 230 kV underground cable. I was not involved with the design of that, but I was observing the cable pulling and the terminations on the incoming gas-insulated substation.
Thank you. So let me get back to your testimony regarding the likelihood of a failure on an underground line. You said it's well over 90% that a failure is going to occur at the splice, I believe.
Yes, my comment on that was that if you look at the actual cables, especially with transmission line cables like that, even distribution cables, the integrity of the cable is very good. over my career of over 50 years, I've seen very few cable failures. Most of the failures I've seen have been on the splices or terminations.
And so does that calculation include dig-ins too, from like, for example, third-party dig-ins?
I would exclude that. These are basically just failures without a dig-in. That's correct.
Okay, so your 9% doesn't include any third-party incidents. Would it surprise you to hear that Rocky Mountain Power had 2 dig-ins to underground transmission lines in 2018?
With similar type of construction as we have here under these specifications?
It wasn't with construction. It was an existing underground line that was contained in a vault.
Yeah, that would surprise me because if you look at the specifications, we're talking about roughly 2 foot square of concrete, red concrete, and then on top of that, there's going to be a fluidized bed of enhanced thermal concrete. So to dig into that cable, unless it's a direct buried cable, would really surprise me.
Yeah, but sometimes directional drillers don't stop for a cement vault, so.
Okay, you mentioned something slightly different. Okay, I understand that one. Directional boring,
So
see that happening.
If you don't have a spare conductor in an underground line and you have a third party that digs into your line, for example, a directional drill, what do you think the impacts of that can be if you don't have a spare conductor and it takes, several months to have that line repaired?
Okay, my observation or opinion on that would be that let's say that we have the incident take place, that we have a directional borer bore into the cable. My recommendation would be if I had only 3 conductors, I would have a spare reel. With a spare reel, what I would anticipate that it would probably take approximately 1 day, at least 1 day, for Rocky Mountain Power to go out, test the cable, isolate it, and locate where the fault is. They can do that with, the test equipment that they have available. At that same time, assuming again, if we're talking about having to order the cable, we're talking perhaps months to get new cable in. But assuming we have a reel, I would anticipate that they should be able to expedite a contractor to get out there within maybe 2 days.
And what if the contractor's not available?
It's amazing how somewhere across the country you can almost always get a contractor.
And based on your experience, how many contractors in the country are capable of coming in and pulling out a damaged underground conductor and pulling through a new conductor?
Okay, there are going to be a lot across the country. The thing is, you're not going to have to pull out the conductor at that time. You have a spare 4th conduit. So it's a matter of pulling the conduit or the cable into the conduit. And then, that can be pulled. You can get your equipment set up on both ends. The time-consuming part is if this is between 2 splices, you're going to have to, splice in the cables. That's time-consuming. That could take 2 or 3 days per splice. Again, I would try to have 2 teams working on that so that I wouldn't be doing one splice then the other. So I think we're talking maybe 5 to 7 days on ending up to repair that damaged cable and put it back into service. On the other hand,
that's assuming that the contractor is available, correct? Assuming that there's a contractor in the United States that's available and can be there and can mobilize. You understand what type of equipment is required to pull these types of conductors through the conduit?
Well, I understand what you're saying.
And are those, is this small equipment or extremely large equipment? Isn't that correct?
Oh, it's going to be large equipment. That's correct. And it's going to take skilled people to do the splices and terminations.
You also mentioned that you based a lot of your estimate on a project that was done in Lower Valley, I believe, up in Wyoming, or by Lower Valley. Is that correct?
That's not totally correct. I looked at those costs, and I based mine on strictly what I felt the project would involve, looking at the specifications, coming up with cable costs, and so forth. So,
did that project
earlier that, go ahead.
Sorry, go ahead. I didn't mean to interrupt.
That project up there was slightly different and quite a bit less expensive than the cost estimate that I did for the Midway project.
Are you aware if that project involved 2 utility companies?
I do not believe it involved 2 utility companies.
And are you aware if that project also involved any underground utilities?
Oh, yes, it did. It involved underground utilities. It involved boring underneath, I think, a highway. It was a fairly complex project.
Excuse me, that was a bad question. Are you aware that there were other existing underground utilities already in place that they had to avoid or go around?
Yes, there were. Now, when you say utilities, I'm considering water, gas, pipelines, sewer pipelines, and so forth being utilities. Are you required just mentioning electric utilities?
Right. And was this Lower Valley project through any residential areas?
I don't know the amount of residential areas. I can't say offhand. I don't know that.
Okay. Let me just ask you a couple questions about your direct testimony that I'm a little bit confused on. It says in your direct testimony where you're talking about the need to do this project. Seems like there's several places in your testimony where you state that that this project should be completed as soon as possible. If you look at page 5, lines 107 and 108, you say with the information provided by our RMP, there appears to be a valid reason for completing the construction as soon as possible. Is that correct?
That is correct.
Is that your testimony today?
Yes, it is. Now, if you look further at that testimony, the load flow studies that were performed by Rocky Mountain Power were showing a single contingency, such as the Cottonwood line going out of service, the Hale line going out of service, and voltages dropping down to the 63 to 73% range. When we do studies, system planning studies in the utilities, we normally try to look at the N-1 contingency. In other words, one source, one generator, one line, whatever's out of service, except for a radial system. We try to maintain 90% voltage or above. So by having load flow studies that are showing that we're down at 73%, 63%, that tells me that Rocky Mountain Power should have been installing a line like this, years ago. So this is definitely a needed line. I concur with that. The question that came up that I was asked was, is it necessary to be done by the end of 2020? It would be nice to be done by 2020. It would have been nice to be done by 2019, 18, 17, probably back to 2015. But, a few months, 6 months or whatever is probably not going to make that much difference from the problems that are existing right now. Do you follow what I'm saying?
Sure, I do. What's your understanding of why it wasn't completed sooner?
I do not know.
Okay. And then I had some question on the distance that you talked about as far as the conductor goes on the proposed underground line. It said that you show a somewhat of a disparity of approximately 1,600 feet in the distance identified in the request for proposals. Did you account for the amount of conductor that is required to come up out of the ground up to the dip poles in your calculations?
If you look at the specifications, first of all, to answer your question, I did it on a per mile basis. So if I need to add another 100 feet or whatever, I would be doing that on my per mile basis. But in looking at the diagrams were provided by Rocky Mountain Power for options 1, 2, and 3, I measured those distances on Google Earth. I went back to the specifications, and they talk about an additional 100 feet that are required at each end. And so with a total of 8 conductors going up on, let's say, the west end, 8 conductors going up on the east end, that totals 1,600 feet. However, the actual circuit distance only goes up by 200 feet, so there's a 1,400-foot discrepancy there. So, in my opinion, looking at the specifications and also looking at the bids, it looks like bidder number 13 used like 5,329 feet for their cost estimate, where bidders 15 and 17, I could see they were using 69.90 for option 1. And so that's where I see the discrepancy coming in with what's in the specification versus what the actual length would be.
And is it a standard practice to use Google Earth to measure distances to bid projects?
To do a cost estimate, yes, it is.
And what's the difference between a cost estimate and a bid?
Well, a bid is being provided by a contractor, and it's basically a determination that the contractor can put the project in for that amount of money. My cost estimate is I try to look at the same thing the contractor does, try to put in some contingencies and so forth so that I meet what the acceptable bid is. So, I would be fairly comfortable going out and, working with a contractor and doing it for the cost that I came up with. That's how comfortable I am with my cost estimate.
I have no other questions. Thank you for your time.
Thank you.
Okay, thank you, Mr. Wright. Mr. Jukes, any redirect?
Just very briefly, there was some discussion about the potential for a third-party dig disrupting the systems that are going to be built underground in Midway. In order for that to happen, did I understand that they'd have to bore through 2 feet of concrete?
There's actually a 2 square foot window of concrete. They would probably have to bore through roughly 3 inches or a little bit more than 3 inches.
How likely is that, in your opinion, based on your experience?
I have not run into that myself, but it sounds like Rocky Mountain Power mentioned they had 2 similar incidents last year. So I can't give you a very good answer for that.
You don't know.
Now, one thing we should mention is that let's assume that we did have such a condition, that somebody was doing some boring there and they went into that particular circuit. You realize that what we're doing with the new Rocky Mountain 138 kV system is we're putting in a full contingency or full plan where we can lose one circuit. So if we had a situation that we lost the Cottonwood line, the railroad line, the Hale line, or this line, that's our -1. So the system could still operate even though there is an outage with the cable or with any one of those other overhead power lines.
Thank you. That's all I have.
Thank you, Mr. Jukes. Anything further from you, Mr. Morris?
No, thank you.
Mr. Reich, do those questions lead to any recross?
No further questions, thanks.
Okay, thank you. Do any board members have questions for this witness?
Yeah, Chair,
I'm not hearing any.
Jordan White.
Okay, go ahead, Mr. White.
Yeah, it's a couple of questions. This is very helpful, Mr. Nelson. Just so tell me if I'm mischaracterizing your testimony, but if if I heard you correctly, you're not necessarily challenging whether the estimates or the design, I guess, specifications of the line are incorrect. It's more that in your professional opinion, there's other ways of doing it that would potentially be different or less expensive. Am I misstating that?
Yes, sir, that is correct.
In your experience working with other utilities, for example, at Excel, in your experience, is it common or is it out of the ordinary to have different internal design specifications for how power lines are built?
I think if you go across the United States, you're going to find a lot of variations with specifications. Some people look at very conservative specifications like the Rocky Mountain Power specifications. There's another extreme that we're seeing with the wind farms. The wind farms are trying to come in with very economical projects. And what they're actually doing is they're utilizing a direct buried system. And there are a lot of advantages to the direct buried where they put the 3 conductors in the ground and put a backfill over those, go up maybe a foot or 2, put in a layer of concrete for protection. And it's a very economical system to put in. The ampacity on the cables are greater. So there's a wide variation of extremes on specifications from direct buried up to a system similar to what Rocky Mountain Power has.
Okay, thank you. The last question I had was just with respect to, I can't remember who was the line of questioning, which attorney was asking you, but I think it was with respect to need. I want to make sure I understand what you said. I think you responded that there wasn't a question in your mind that there was a need. It was just a question of whether it could be prolonged. In other words, there was a reliability issue or a need for the project. It was just, you explain a little bit more about that. You said that it was a need, but it could wait longer, or?
Yeah, yes, sir. There are 2 areas that you may be directing at. Number one is, if there were a failure of the underground cable, my recommendation would be that Rocky Mountain Power have a spare reel. That spare reel would probably be about $100,000 of inventory, so there's a cost associated with that. The alternative is they would have to buy that cable, and if it's not in stock and it may not be in stock, it could end up being, let's say, 90 days out or maybe even longer before they could get the cable replaced. So that's an issue there. The other issue is, if there is an outage on that line, right now, any outage on the Cottonwood to Snyderville, the railroad coming down into the Park City area, or the Hale line coming in, would cause an overload on the system and low voltage. So by putting this line in, they're back up to the full end contingency. If they got all their system together, they could lose any one of those sources, including this Midway underground line or the line itself, and still be able to maintain voltage 90% or above, according to what I understand with the load flow studies. Does that answer your question?
Well, I think it does, but at one point I thought you said, and maybe I misheard you, that you said that overall the general impetus for this project is you're not questioning it. In other words, there is a need. It's just a question of whether or not the timing.
Yeah, definitely there is a need. The timing is the question. The need has been there for years, in my opinion. So it needs to be installed.
Okay, that's all the questions I have. Thank you very much.
Sure.
This is Thad LeVar. Thank you, Mr. White. Do any other board members have questions for Mr. Nelson? I'm not hearing any questions, so thank you for your testimony today, Mr. Nelson.
Sure, you're welcome. Thank you.
And I think what we'll do is we'll take one more 10-minute break right now, and then we'll come back and let Midway City call their next witness. Why don't we go into recess for approximately 10 minutes? Thank you. And at this point, we will go to Midway City for your next witness.
Thank you, Chairman. We intend to call Mr. Jerry Weber as our next witness, and I'm not sure if he's on the line yet. Are you there, Jerry?
I'm on the line.
There we go, like magic. Love it. Thank you. Thank you for being here, Mr. Weber. My name is Joshua Jukes, and I'm an attorney for Midway City in this case. Appreciate you taking time out of your day to visit with us.
Okay.
And Mr. Jukes, I'll go ahead and swear him in. Mr. Weber, do you swear to tell the truth?
Yes.
Okay, thank you. Go ahead, Mr. Jukes.
Thank you. And Mr. Weber, have you had an opportunity to look at the direct written testimony that's been submitted on your behalf in this case?
I have.
Does it accurately reflect and completely reflect your testimony in the case?
Yes.
I'll move to submit Mr. Weber's testimony in evidence as his direct testimony in this case.
This is Thad LeVar. If any party objects to that motion, please indicate your objection. I'm not hearing any objection, so the motion is granted. Go ahead.
Mr. Weber, I just have one or two quick questions for you. In your look at the value of these easements, did you do individual property appraisals?
Yes, I did. I did the individual property appraisals, and my scope of work was really because the location and width of the proposed easement was unknown, is to estimate the impact of the power corridor to the property value if the power corridor were to be installed.
Did you come to what you determined to be a value of the impact that you're referring to?
Yes, I did for each individual property I think there were 51 properties that I did appraisals on, and I did on each individual property.
Do you recall the aggregate value?
The total, according to the spreadsheet, which included one property that was a duplication, I think it was property number 84 was a duplication, which I pointed out in my testimony. The impact was about $3,445,162.
That number reflects the total aggregate impact of the easements across all the properties. Is that right?
Yes, it does.
All right. I think that's all the questions that I have. I know that some of the other attorneys may have questions for you.
Thank you. Mr. Morris, do you have any questions for Mr. Weber?
I do. Thank you. Mr. Weber, please tell the board what was your scope. We know that you performed appraisals on these individual properties, but what were you comparing? And to come up with the numbers that you did?
Well, I appraised the properties as though the power line corridor was not installed, and then estimated the damages to each individual property based upon each individual property's proximity to that power corridor.
And when you say power corridor, are you speaking of the proposed overhead corridor coming in?
Yes.
Okay. You're aware that there's an existing power corridor there now?
Yes, I am.
Okay, and so you didn't assume there was no power corridor at all for your before valuation?
No, I assumed the before valuation with whatever easements and power corridor was impacting those properties prior to the installation of this proposed 138 kilovolt power corridor.
Okay. So in looking at your report, there's a picture. Looks like it's one of the last pages there. It's an impact map. Do you see that? It might be the last page on your report.
Yes.
I'll give everyone a minute to get there if they're looking at their own exhibits. Now, you didn't prepare this impact report, did you?
No, I did not. That map I did not prepare.
Okay. Now, does the map accurately describe, with the blue numbers, the properties that you did individualized appraisals for?
Yes, it does, with the exception of what they've referred to as property 41. They've got that in red. I did do an appraisal on that, which I amended in my testimony to reflect the fact that that property should have been included with the summaries. And property 32, I did not do an appraisal on. And then the duplication, which was they refer to as property number 10, is a duplication, and they have it listed as property number 10 and also as property number 84. So that was the duplication, which I pointed out in my testimony, which I submitted.
Okay, thank you. I noticed that, for example, property 31, which is up on Cascade Meadows Loop. Do you see that?
Yes.
Could you tell the board why you believe that property would suffer a loss in value if the proposed double circuit line is installed by Rocky Mountain?
Well, that property kind of sits up on a little bit of a hill. Its view shed is to the south and to the southeast, which would be directly into where that power corridor, as it extends westerly along Ward's Lane, would have extended, or would be proposed to be extended.
Okay. And is your understanding that this corridor is going to run across the street from Ward's Lane from that subdivision?
Yes. Yes.
Okay. And for developments that are HOAs and have common areas, did you encounter those in your work?
I did. The majority of the homes and the vacant lots that I appraised were in Cascade Springs. It's for Soldier Hollow at Cascade Springs. The subdivision is I'm looking at them. There's so many subdivisions that they're named. The Cascades at Soldier Hollow were the majority of the lots.
Okay. Looking at this map, there are some big red circles that are called out as 7-foot diameter, 85 to 115 foot steel poles, and I see 3 of them there. Do you see that?
Yes.
Did you understand that these were not the only poles that were going to be installed?
Yes, those are the poles that would represent the corner poles and would, the most likely scenario would be the largest of the poles, because they would have the tension based upon being in the corners, where the power line either takes a northerly turn or a westerly turn.
Okay. You've concluded that there will be a negative impact, and you've put a dollar figure into it. Tell the board what the basis for your calculations was. Let me preface that with a better question, a little more background. Did you arrive at a general percentage of loss in value that would be occasioned by installation of this double circuit?
Yes, I did.
And what is that?
Well, depending on the proximity to the double circuit corridor and structures, anywhere from 2.5% to 10%, depending on proximity to the proposed power corridor installation.
And the properties that are going to get these 7-foot diameter steel poles, is the impact greater on those?
I would think it would be, but of course, at the time, we didn't know where those poles were to be located. I assumed that the larger poles would be in the locations as noted on that impact map, that those would be the large poles, similar to the pole included in that photograph on that impact map pole. That pole is actually at about 400 north and Highway 40, on the east side of Highway 40, just on the north end of Heber City. That's where that pole is located.
Thank you. For properties or for homes that are within an HOA, but do not necessarily abut the proposed power corridor, explain to the board how the impact, how the value of those homes is impacted.
Well, it would depend upon their proximity. Those homes that are near the power corridor, numbers in Cascade Springs is numbers 68, 60, about 68 through 41, and then includes parcels 78, 79, 80, 81, 82, 83. Those are part of the Cascade Springs at Soldier Hollow, PUD. That project includes common area trails, common area landscaped areas, and also some common area water features. So each property in that project has an undivided interest in those common areas. And the big part of the common areas would be along the north boundary of the Cascades at Soldier Hollow, as it abuts Ward's Lane.
And so, just because a home isn't necessarily on the line, it's the value of its interest in a common area that is on the line is affected.
Well, yes, and it's also the impact to that home from being in close proximity to that power corridor.
Do you have, well, let's see, you gave us a big summary of your trial testimony, so we won't go through all of that. I think that's all the questions that I have for you, Mr. Weber. Thank you for your time.
Okay, thank you.
Thank you, Mr. Morris. Mr. Reich, do you have any questions for Mr. Weber?
I do have a couple follow-up questions. Hello, Mr. Weber. This is Brett Reich with Rocky Mountain Power. How are you today?
Good.
Good. Thanks for joining us. On your direct testimony on page 4, on line 82, in response to the question about do you have an opinion regarding severance damages to the properties, your answer says, are you there, or do you want me to give you a minute?
Let me find it. You're on line 82?
82, correct, at page 4.
Yes.
You say, I concluded that proximity to the proposed above-ground or overhead power lines impacted these properties. And my question is how did you make that determination?
I did it in two methods. I did what we call a qualitative analysis, where I discussed the potential power corridor with various real estate agents, participants in the marketplace, buyers, sellers, mostly agents and brokers, and discussed the possibility of the power corridor not being there and what the impact they felt the installation of that large power corridor would have on the adjoining properties or the properties in close proximity.
So
And that summary is included within the body of each of the individual reports. That was the qualitative method.
and let me just ask you a question about that before you talk about the second step. When you say you ask them questions about how it would affect the property, or I'm not trying to misstate. If I misstate, please correct me. You're saying without the new line in place. I guess that I don't understand that. So you're asking them how would their homes be impacted without the new line in place? I don't understand that.
What was their perception of the impact on the value of their property? As a result, yes, on the impact of their property as a result of the power line installation.
Okay. Got it. And which specific individuals or property owners did you talk to?
I talked to many property owners, and I talked to most of the property owners of the homes I appraised within Cascade Springs, or the Cascades at Soldier Hollow, for each individual property as I was conducting the appraisal. I also discussed it with many real estate agents that are active in the market in Midway, Heber City, to get a feeling as to their perception of the impact of the power corridor installation to each property values in the area.
And have you found in your practice as a real estate appraiser that property owners are a good indication of how the value of their home is going to be impacted by developments in the area?
No, because I think they might have a vested interest in the outcome. But I do consider it. They're obviously market participants. They are familiar with their own property, and they're familiar with the reasons they bought that particular property. So
okay.
They certainly should have some input into what impact might be from some external influence. So I discussed it with them. I think the real estate agents generally are a little bit more objective because they represent buyers and sellers in the marketplace. They try to be objective and in their practice of real estate in representing buyers and sellers, and hear feedback from those buyers and sellers. Some agents reported that they were told by some specific buyers they would not buy a property in close proximity to a high voltage transmission power line. So they didn't even bother showing them to them, so that they felt those particular individuals more adversely reacted to proximity to high voltage power transmission lines.
And do you consider the existing 46 kV a high voltage power transmission line?
Well, it's a moderate, it's medium density, it's medium. It's certainly not the capacity of the 138 kV that's to be installed.
Okay. So, and then you said it was a two-step process. So first you talked to the homeowners, and then to some real estate agents, and then what was the second step?
And that was the qualitative analysis. And so I got the feedback from those individuals, and I went out and I compared homes, and I had a pretty good what I refer to as a paired sale, in that the property on Whitewater Lane, which I was in the process of appraising, had just gone under contract. And the seller reported to me that when the new buyers found out about the possibility of a power corridor being installed immediately north of that home, they withdrew their offer. He then renegotiated with an additional buyer and felt that he had taken a discount. I appraised that particular home for, I'd have to look at my notes, but I think it was $1 million. Let me tell you what that one was. That's property. Let's get to the map. One of the confusing things on this is the properties, as identified on the impact summary, are numbered by the numbering system that the preparer of that document came up with. But it's on Whitewater Lanes, property 51. I appraised that property without the easement, without the possibility of the proximity to the power corridor, at $1.06 million. It actually sold for it was sold for about $950,000, which represents about a 10% decline in value. Since that time, there have been two other paired sales within the confines of Cascades at Soldier Hollow. Property that's located a little bit further away from the power corridor, 920 Coldwater, which is property 66, I appraised for $1,100,000. That property ultimately sold for $1,035,000, which is a decline of just over 5%, about 5.40% decline in value from what I appraised it absent the power corridor, and what it sold for with the possibility of the power corridor was a discount of about 5.4%. I estimated that decline in that property to be about 5% when I did that, because it was not under contract or sold at the time I appraised it. It was listed for sale. Another property, which has since sold in the Cascades at Soldier Hollow, is the property at 908 Cascade Court. The time I appraised that property, that one is identified as property 45 on the map exhibit. That property was listed for sale when I appraised it for $2,250,000. I appraised it under the assumption that the power corridor did not exist and the threat of the installation of the power corridor did not exist. I appraised that property for $2 million at the time, which was in, as I recall, May of last year. That property ultimately sold for $1,765,000, which is a decline of about 11.75% below what I appraised it for. So
and when did that property sell?
That property sold in August of 2019. I appraised it, I think, in May or June of 2019.
And what did you attribute the 11% decrease to?
Well, I didn't attribute the 11% decrease. I estimated the diminution in value from the proximity to the power corridor to be 10%. That property actually sold for 11.75% less than I appraised it for. So the impact was more severe in that case than I had estimated. I have three what I call quantitative analysis of sales that have sold within proximity to that particular power corridor.
Yeah, let me just clarify on your statements that you do an appraisal. I mean, this power line has not been built, correct?
It has not. No.
So you say you do an appraisal, like for example, on the last one, you said that you did an appraisal of 2.2 million, and
$2 million.
Excuse me?
I appraised it for $2 million.
$2 million.
At the time I appraised it, the property was listed for 2.2.
Okay. You appraised it for $2 million, and then you say you do that. I think your words are without taking into consideration the power line. Is that correct?
Yes, without taking into consideration the threat of the installation of the power corridor. I'm appraising the property as though it exists, and there is no threat of installation of the power corridor. I appraised that property for $2 million.
And so when it's sold and there's a decrease, and you said it decreased by 11%, are you attributing that to the threat of a power line, or is there some other factor, or are you not offering an opinion on that?
Well, I'm not offering an opinion as to why it sold for less, other than the fact that when I appraised that property for $2 million without the power corridor or the threat of the power corridor, and it ultimately sold for $1,765,000, that's a decline. The only thing that I can determine as to why that happened was that the buyers, the sellers in the marketplace, became aware of the installation or the potential installation of the power corridor immediately north of that site.
But, I mean, you would agree with me that the threat of a power line existed on May of 2019, correct?
It did.
So, looking at the map that Mr. Morris referred to, that's part of your testimony, it identifies several properties in blue, and those say appraisals received. Is that correct?
I guess, yeah. Those yes, and that was prepared. I don't know who prepared that. I think it was someone at Volt.
Okay, so this is attached to your testimony. That's why I wanted to ask you about it. So, are the blue numbers, are those the appraisals that you conducted?
Yes.
And how did you decide?
With the exception of property 32, which I did not appraise, property 41 I did appraise, and property 68 I did appraise.
Okay. And my question is, how did you decide which properties you were going to do appraisals on? Were you given an assignment to do specific properties?
No, I requested telephone numbers and contact information from my contacts with Volt to the property owners, and in most cases they happen to be owner occupants. Then I would call those owner occupants, explain what I was doing, request a time to inspect their property. In some cases, some of those property owners refused access to the property for whatever reason they had chosen not to allow me in. So I appraised those properties from the exterior based upon Wasatch County records in terms of bedroom count, square footage, those kinds of things, by making exterior inspections.
So there are some property appraisals that you did on residences that they did not give you authority to do an appraisal on.
They would not allow me inside. Yes, that is correct.
And
those properties are clearly identified in the summaries of the appraisals that were submitted. But I did not inspect the interior. Okay.
And so that explains why you did the 51 appraisals that you did do. So why, for example, why didn't you appraise The property identified as 37 or 34.
37 and 38 is owned by the same person, and I had talked to him, and that property is primarily vacant land. There is a smaller home up in the north corner of property 38, and so I just didn't get an inspection of the interior of that property, so I never completed an appraisal on it. But I had spoken to him at the time. I think he was up at his ranch in Wyoming, and his wife didn't want to let me in until he got back, and that was going to be later on in the fall of 2019. So I just never did it.
So I'm still a little confused. Maybe I'm asking a bad question. So how did you select these 51? Are these the 51 that you just decided on your own, hey, I'm going to do appraisals for these 51 properties?
Yes. After I'd done the research and done the qualitative and quantitative analysis, I felt that the properties were located in not in close proximity to the power corridor probably had no impact as a result of the installation of the proposed power corridor. So I was more concerned with those properties in closer proximity of anywhere from 20, 30 feet in some cases to as much as maybe 200 feet in some cases. So that's why those properties are kind of along that power corridor area. Many of the homes in Cascade Meadows, PUD, were under construction at the time I was doing these appraisals, and so I just didn't do those appraisals. They were under construction at that time.
So did you receive an assignment from anyone to appraise these 51 properties?
No, I was requested to appraise all of them if I could. Unfortunately, I was not allowed access to many of the properties. We couldn't get contact information for some of the property owners. So I just didn't complete them all.
So is it your understanding, and I know you didn't, it sounds like you did not complete this this exhibit. There's a picture of a pole here. Is it your understanding that that's the type of pole that's going to be placed in these three
That's the pole. Yeah, that's the pole that I actually looked at. It's on the north end of Heber City, right there on Highway 40.
Okay. And is it your understanding that the poles that are going to be on this map, the three poles that you've identified, are going to be similar poles to that pole?
That's what I was told. Yes. I don't know.
By who told you that?
I think the people at Volt, Ben Johnson, and some of the people at the Planning and Zoning Department at Midway City.
And would it change your analysis at all if I told you that that pole is not the pole that's going to be used in those three places? The pole in the picture here has distribution lines on it, and the proposed the proposed project does not have distribution lines.
No. I was told by Midway City early on in the process that whatever poles would be installed only with the high voltage power lines. Distribution lines would be elsewhere or be relocated below ground.
And do you understand the pole that's on this picture shows distribution lines on it?
Yes, it does.
Okay. So is that an accurate representation of the poles?
No, not truly, but it shows it has distribution lines on it. But I was told that's the similar metal pole structures that were to be installed on the corridor locations. I'm not certain what would have been installed in between the corner locations.
Okay, and with respect to the poles, I think you were asked by Mr. Morris about, if there were a pole in front of somebody's property, if that would impact the value of the property. Are you aware that the project has been designed as requested by Midway City by moving the poles to the property boundary lines so they're not directly located in front of any of the residential properties?
No. No, I wasn't told that.
And would that change your opinion at all if that was your understanding?
No, because at the time I started on this project, I had no idea. Nobody had any idea where the poles would be, what size the poles would be. I was basing my analysis on what would be typical construction for 138 kV line in the area in terms of required right-of-way width and in terms of pole spacings and elevations of lines.
Also, if you were told that the number of poles is actually being reduced in this area in comparison to the existing power line, would that change your analysis at all?
No.
And why not?
Because I think the existing poles are anywhere from 40 to 50 feet in height, and the proposed lines would have been anywhere from 100 to 110 feet in height. I think they'd be much more invasive, much more impactful to the view sheds.
And what's the basis of your opinion that the new poles are going to be 100 to 120 feet in height?
Well, it's based upon my research as to the required pole size and elevations for that size of a line, based upon construction standards that I researched myself. And I also discussed it with Midway City planners and people on Midway City Planning and Zoning, and they all felt that the poles were going to be anywhere from 90 to 120 feet in elevation.
And if you were told that, pursuant to the route and the poles that were selected by Midway City, if this project goes forward overhead, that most of the poles are going to be 75 feet in height, would that change your opinion?
It might, but I think you've got to look at the pole spacing and where those poles are really going to be located.
Okay. And then my last question has to deal more with, and I believe I just need a better understanding of this. It looks like some of the properties that you've provided an appraisal for are not touched by the proposed or the existing power line easement. Is that correct?
Yes.
And what's the basis then of your analysis that would include some type of damages for properties where there would be no physical taking?
That the views and the proximity to the poles would impact the value of those properties.
And what's the basis for finding that there's proximity damages?
I found no evidence that high voltage transmission lines present a health hazard. But unfortunately, many people you discussed power lines and electromagnetic fields with feel that they do. And that seems to be their objection. I've never found any empirical evidence that it exists. But
we would agree with you on that. Sorry, I didn't mean to interrupt you. I just couldn't resist.
But, there's no empirical evidence that exists, but it does exist in the minds of the buyers and the sellers in the marketplace.
And so your basis for including proximity damages is that there are homeowners that have a concern for electromagnetic fields?
I don't know if they have concern with electromagnetic fields, but they resist buying properties in close proximity to high voltage transmission lines. I think one of the most concerning things expressed by most agents and most property owners in the area is the elimination of some of the views that those power poles and power lines possess.
And so that your understanding as a certified appraiser that if a property owner is not there's no physical taking for a property owner, they can still receive severance damages if their views are impacted by some type of improvement that is not located on their property.
Yeah, that's a legal question. I don't know.
Well, I didn't ask if the law allowed it. I asked if, based upon your experience as an appraiser and based upon the rules and the what you use to appraise properties, if it's your understanding that that gives a person the opportunity to receive severance damages.
Well, I've been involved in cases where traffic noise, where navigation easements have impacted property values, and the market recognizes that there is proximity damage.
Thank you, Mr. Weber. I have no other questions.
Thank you, Mr. Reich. This is Thad LeVar. I'm sorry, I can't remember if it was Mr. Gordon or Mr. Jukes who had done the original questioning of this witness, but whichever it was, do you have any redirect?
It was actually Mr. Jukes. I don't believe we do. Mr. Jukes, do we have any other questions?
No, Your Honor, no further questions.
Okay, thank you. Do any board members have any questions for Mr. Weber?
Mr. Chairman, I just have one question. It's Mr. Morris.
Okay, go ahead.
Mr. Weber, if you had had more time, I mean, you did a lot of appraisals here. If you had had more time, would you have finished more of these on the map than you did?
Objection, calls for speculation.
I'm going to overrule the objection and allow him to answer the question.
Yes, one of the difficulties was just arranging times when the homeowners could meet me at their properties when I could actually inspect the interiors, and trying to coordinate that.
Thank you very much. I have nothing else.
Okay, thank you. Do any board members have any questions for Mr. Weber?
This is Dave Clark. I've got a question. Mr. Weber, is there anything with respect to properties numbered 1 through 8, and I would include in that 76, that is a consistent reason for those appraisals not yet being completed?
I just never got to them. A couple of those properties are some vacant lots. I think 6 has some vacant land with it. So no, I just never got to them. Property 75.
Thank you very much. Go ahead, please.
Property 75 is a planned unit development, which has a total of about 58 units. And at the time I did that appraisal, the owner was in the process of amending the plat to be, I think, 38 PUD lots versus a clustered development as it was approved. So they were in the process of getting that modified. So that property, as it shows on the map, is a little bit different than what the property owner was in the process of amending the plat to look like.
That's all. My only question. Thank you.
Thank you, Mr. Clark. Do any other board members have any questions for Mr. Weber? I'm not hearing any questions, and I don't have any. Well, thank you for your testimony today, Mr. Weber.
Thank you.
And now we'll go back to Midway City if you would like to call your next witness.
Thank you. I'll just hang up. Thanks.
Thanks.
Okay, Mr. Gordon or Mr. Jukes? You might be on mute. We're not hearing anyone from Midway City. Mr. Gordon or Mr. Jukes, if you're speaking, you must be on mute. We're not hearing anything.
I'm sorry, we had to redial. My bad.
Oh, I'm sorry.
Yeah, this is Mr. Dukes. No, we have no further witnesses to call from our case.
Oh, you're not going to call Mr. Wilson or Mr. Henke?
No, we are not.
Okay. Do you have anything further then?
We do not.
Okay, I'll go to Mr. Morris then. Would you like to call your first witness?
Mr. Chairman, I had inquired of the other parties whether they had any interest in cross-examining my two witnesses, Mr. Johnson and Mr. Lowry. And I think counsel for Rocky Mountain indicated that they didn't at the time, but they would let me know. They haven't let me know. I don't have either of my witnesses available right now. We've moved today a lot quicker, as you know, than we did yesterday. And so, number one, I don't know if anyone wants to cross-examine my witnesses. And number two, even if they did, I did not have them ready today. All of this was a lot faster today than I thought.
Okay, well, thank you, Mr. Morris. Why don't I talk to the parties then about the remainder of some of the issues we have in front of us. I just want to let the board know, once we conclude the presentation of evidence, then we still need to deliberate as a board in a public hearing during part of the time that we've set aside this week to do that. So we need to have deliberation, and as a board, we need to probably decide whether we want the attorneys on call to answer questions while we're deliberating, whether or not we do that. So that's just an issue I want to make sure that all the board members are aware of that we will need to do in connection with this. Our statutory due date for issuing an order appears to be May 8th, which is 2 weeks from Friday. So that doesn't give the Public Service Commission staff very long to draft an order once this board deliberates and makes a decision. And the other thing I wanted to ask then before we adjourn today is whether parties have an interest in closing statements. So let me just go first to Mr. Reich and then to Mr. Gordon and Mr. Jukes and then Mr. Morris, whether you have an interest in closing statements before the board deliberates.
We would be happy to do that if the board thinks it would be helpful. If not, I mean, we would just be as happy submitting a written final statement or brief on the issues that have been discussed. We'd be happy to do that also.
So you're expressing a willingness to do either, but not necessarily asking to do either. Is that right, Mr.
Well,
Wright?
Yeah, if I could do my preference, I would do the second and just submit a written submission.
Okay, well, let me ask this. Considering that the board probably is going to need to deliberate and make a decision during the time we have scheduled for this hearing this week, is a written brief feasible? I mean, if we're going to deliberate tomorrow or Thursday, I don't think, because I think that's the time frame we need to do it to get someone drafting our order. Obviously, it's not possible to get written briefs in our hands and read before that, correct?
Well, we could do it by tomorrow at noon or something, but we'd be happy to do a oral concluding statement also.
Okay, and maybe I should just get the issue out there and we can wrap this conversation up tomorrow morning. But I just wanted to get the thoughts initially. Mr. Gordon or Mr. Jukes, do you have thoughts on this issue? Sorry, if you're there, we're not hearing you again. I don't know if we've lost you again, Mr. Gordon and Mr. Jukes. Let me just jump to Mr. Morris. Do you have thoughts on closing statements or written statements?
Because I think it would be less expensive and time consuming for my client if we just did an oral summation. 10 to 15 minutes is all I think I would need, and rather than put together a big closing written thing.
Okay, thank you, Mr. Morris. Mr. Gordon or Mr. Jukes?
Yes, I apologize. We've had a little too much caffeine up here. Commissioner, we keep hitting the wrong button. So we would like to do an oral presentation as well. Same estimation, probably 10 minutes, maybe longest 15. It would be much easier for us to do that than try to submit something in writing. And so we would ask for that privilege.
Okay, well, let me propose this then. If any board member objects to this, please let me know. But it seems like we should ask the parties to be prepared for some kind of verbal closing statement, probably mid or late morning tomorrow after we finish the remaining two witnesses. Is there any objection from board members or parties to that? And then the board will need to decide if we need a break before we have a deliberation portion of this hearing. If anybody has any concerns with that path forward, please indicate it.
This is Dave Clark. I support the path forward, but I'm not certain that we've resolved whether the two Volt witnesses need to appear at all. And if they don't, then we could just start with the arguments. Would be my thought.
Okay, from Mr. Morris's comments, it seemed like that wasn't something we could resolve this afternoon. Can that be resolved this afternoon, or is that something we're going to have to put on hold till tomorrow morning? Mr. Morris?
It's a function of whether Rocky Mountain or Midway want to cross-examine either of my witnesses.
Are either of those parties ready to indicate now whether you have cross-examination for Mr. Johnson or Mr. Lowry?
Midway City has no intention of cross-examining either witness.
Okay, Mr. Wright?
And we are similarly have no questions. I'm assuming you're still going to proffer and present their testimony, but we have no cross-examination questions for either witness.
Based on that, Mr. Chairman, I would proffer the direct testimony of both Mr. Johnson and Mr. Lowry, together with any exhibits attached to them.
Okay, if there's any objection to that motion, please indicate your objection. I'm not hearing any objections, so the motion is granted. So it looks like, as Mr. Clark indicated, we could probably start with closing statements at 9 a.m. tomorrow. I think probably roughly 15 minutes apiece. Does that seem to be what everybody was indicating? Is there any objection if we ask them to be roughly that length?
No objection from Rocky Mountain Power.
No objection from Midway City.
No objection from Volt.
Okay, we will move forward that way. We'll hear closing arguments first thing, and then I'll ask board members, should we move directly into deliberation as soon as closing arguments are concluded? Is there any objection to that, doing that in the morning?
This is Glenn Wright. I have no objection to that, but I do have a question. I've found Lowry's testimony that I can reread tonight. I don't have I can't exactly find Johnson's. If that could be retransmitted to me, I would appreciate that.
This is Thad LeVar. I will email that to you as soon as we conclude today.
Okay, good. Then I'm good as fast as possible.
Mr. Chairman, there's one thing I'd like to bring up before the record closes.
Is this Mr. Morris?
Yes, I'm sorry.
Yes, go ahead.
Thank you. First of all, I want to thank the board again for allowing my client to intervene and participate in the proceedings. Before the record formally closes, I wanted to ask the board to take judicial notice of something that I don't think made it into our exhibits. And again, it was a function of trying to have everyone working from home. You'll note that the first two Volt exhibits are pleadings from a case that Rocky Mountain Power filed some years ago concerning a transmission line over Sitla land where Rocky Mountain posited that there would only be $70,000 in easement costs and severance damages. And I did want to get into the record the very public final result of that dispute in terms of the amount of money Rocky Mountain ultimately had to pay. In connection with that, I've got a Salt Lake Tribune newspaper article from, I think, the following day. It's May 17th, I think, of 2014. I don't think it's in dispute. I don't think there's any argument that this is what occurred, but I do want the record to at least contain that fact. And I think that the dollar amount was $2.5 million, as reported in the newspaper.
Okay, this is Thad LeVar. Just to clarify, are you making a motion to get? I mean, I see those first two exhibits you're referring to. Are you making a motion to get the Salt Lake Tribune article also in the record? Because I don't see that currently with the Volt exhibits. Is that an additional document you would like to provide to the board?
Yes, it is. It was my intent to have both those opening pleadings and then a concluding pleading, but I don't think the court file reflects the settlement amount. But it did. It was a public settlement involving Sitla, and the Trib the next day just reported the settlement, and I guess I'd prefer to have something on paper in the record showing that what started as a $70,000 approximation turned into $2.5 million.
Okay, and you have that article ready to provide to the board based on the result of this motion, is that correct?
Yes, I could email it shortly.
Okay, is there any objection from any other party to this request or motion?
Yeah, this is Brett Reich, Rocky Mountain Power objects. These pleadings are completely irrelevant to this proceeding. They have no bearing, no probative evidence that's contained in these. Mr. Morris has already misstated that there was an order for Rocky Mountain Power to pay when it was a settlement agreement. So for all of those reasons, we'd object to this.
I think my inclination, for the same reasons we let in the testimony regarding the valuations in Tooele, I think there is some value, and I think we could take administrative notice of this and give it the appropriate weight in context of the evidence that we're evaluating. So unless there's any objection from other board members, I think I intend to grant the motion and allow it to be provided to the board members and possibly discussed in your closing arguments tomorrow. And I'm not hearing any objection for board members, so that will be the ruling on the request. Any other matters to deal with before we recess today?
This is Glenn Wright again. I did find the Johnson deposition, so I'm good. I don't need any more information.
Okay, thank you, Mr. Wright. Well, with that, then I think we will plan to have closing statements at 9 a.m. tomorrow and move directly from that into a deliberation session with the board members. We are in recess until 9 a.m. tomorrow. Thank you.